Right, good morning everybody. It's 10 o'clock and this inquiry is now open. I'm assuming everyone can hear me. We might see how we go without it at times then. My name is John Wild and I'm a Chartered Civil Engineer. I've been appointed by the Secretary of State for Levelling Up Housing and Communities to both conduct this inquiry and determine this appeal. It's an inquiry into an appeal by Little Great Britain Limited, made under Section 78 of the Town and Country Planning Act 1990, following the refusal of planning permission by Brentwood Borough Council. The scheme proposed is for the demolition of all buildings and structures and the construction of a Class A1 food store and Class C3 dwelling houses, together with access egress from Ongar Road and Berlin Road, car parking, landscaping, replacement substation and associated engineering works at land at Wates Way, Brentwood. A few housekeeping matters. Mobile phones on silent or off, please. I gather we don't have virtual participants. I've got no screens round with people on them, so I assume it's just here. Is this been live streamed? Yeah. Okay, thank you. Are we expecting any fire drills today? I've got a few blank faces at the council, which is always slightly worrying. Okay, so if we hear an alarm go, it's the real thing. Can someone from the council explain how we get out? Because I'll be following you. So we go up these halls here at the back, to the rear, and straight down the stairs, straight out. Okay. Is there anybody in the room would need help getting out if we did have to evacuate in a hurry? No? Okay. Does anyone intend to film or record any parts of the inquiry? That's a bit superfluous because it's been live streamed anyway. My opening today will establish a procedure to be followed for this inquiry. If there are any questions, I'd be grateful if you ask them at the end when I've finished. Hopefully by then you should know what it's all about. May I now take the names of those persons who wish to speak at the inquiry? For the appellant, please.
So, good morning. My name's Reuben Taylor. I'm King's Counsel. And Reuben spelled R-E-U-B-E-N. Taylor is much easier to spell, T-A-Y-L-O-R. I'm instructed by Rapley's, and I have got three witnesses: Mr. Budd, who deals with highways issues, Mr. Koshi Charek, who deals with planning issues, and Dr. Srimath, who deals with air quality.
Thank you, Mr. Taylor. For the council.
Yes, so I prepared a list because I'm conscious that people's qualifications are not obviously automatic, so I'll just distribute. So I am, I'll use my voice. I'm William.
Okay, thank you, Mr. Upton. Are there any other persons, interested persons, wish to speak? Gentleman at the back.
My name is Frank Garbutt.
Yep.
And I'm a resident in Brentwood.
Do you have what you wish to input in writing?
I've got very simple notes. They've already
Okay. Only if it's printed out or at least it's copied, then I'm a very lazy inspector. It saves me having to write down everything you say.
my bullet point. I was going to say it's better than a fact packet.
Okay.
But if you want to take a mobile phone photograph of it,
That's far too technological for me. No. Could the council photocopy it?
yeah.
Okay, thank you. And it just saves, everyone can then have a copy, we've all got the same thing. I'll try and fit you in fairly early, okay? Bear in mind, it's not helpful to me to hear the same thing put several times over and over. It doesn't carry any more weight. So, but I'll fit you in as soon as I can today. Excuse my voice, by the way, I've had a cold, and it was obviously a man cold, so you ladies wouldn't understand, but... Sorry, there's a debate within PINs whether we should even do them these days because of non-disclosure, all that sort of stuff. But I think if we could have one doing the rounds for each day, it would be helpful. More consternation on the faces of the council.
yes.
Okay, thank you. If you do not wish to see other people to see your details on that sheet, then just ask for a separate sheet and it will be given to me so no one else will see it. Okay. I don't think I've seen a copy of the council's notification letter giving details of the arrangements for the inquiry. It may be in the bundle somewhere, but if I could have a copy, I mean, I'm pretty sure by the fact that people are here that we all know about it, so...
So others may have been in the same position.
Okay, but I think most people know about it, and I've certainly had, I'll come to that in a minute, correspondence from various people. In fact, I come to it right now. I have received direct correspondence from a significant number of people regarding this appeal. I will not use inquiry time to read out the names, but suffice to say that that correspondence and that received at the application stage will be taken into account when I determine this appeal. I have received and read proofs of evidence on behalf of the appellants from Mr. Jim Budd, Dr. Srinivas Srimath. Is that anything like right? Okay. And here we go. Mr. Martin Kozicharak. Is that anything? In which case, I think we'll adjourn now and I'll just go on top of my game, you know. I mean, I've also received and read a rebuttal from Mr. Budd. On behalf of the council, I've had proofs of evidence from Ms. Hilary Gore, Mr. Ian Henderson, Ms. Katie Parsons, and also a rebuttal from Mr. Henderson. I'm pretty sure that the proofs of evidence have been exchanged between the parties. Is that correct? Yes. And are there spare copies and proofs for interested parties, even though we've only got one? But I think they're all online anyway. And I've got to say, this is an opening that came from about 15 years ago, which has been amended over the years. I think it's probably slightly out of date now because all proofs of evidence are online and presumably are public documents anyway now. So I might even change that after this inquiry. You never know.
People do want hard copies, we can provide.
Yeah, okay. We are trying to save trees though, and I'm even doing this opening from a laptop, so this is progress. I don't think I've received a 106. I think that's still under discussion, is it? And I get the impression we'll be talking about that in a round table later on in the inquiry. So hopefully at the end of that I'll be getting a signed and dated section 106, and obviously I'll allow time after the inquiry for that to happen. In terms of plans, suggested condition 2 on the list of suggested conditions lists the relevant plans. Is everybody happy I use that if I were to allow the appeal on the decision letter? Yeah. Okay. Talking of plans, I've already mentioned this briefly to the council. I could do with at least one decent sized plan. I've been trying to do it off A4, which is utterly useless. So, particularly as we're talking about a junction with different movements, it will be really useful. You know, I'm an engineer, I like pictures, it's simple as that really. So anything you can help me out with that, I'd appreciate it. I mean, even A3 would be help over A4. Okay, so are there any bigger ones anywhere? Have people not used them these days? Are there no proper engineers amongst us? God. Sorry. I will try and keep alive for the rest of the 3 days. Right. The inquiry is scheduled to last 3 days. Timings have been interesting that I've been getting over the last week or so. The latest ones, excuse me, the latest ones I've had indicate we should just get through it in 3 days, but presumably that will mean final submissions Thursday afternoon, which necessarily won't give you gents that long. I do normally like to give barristers overnight to do it, but I think that's where we're at. So, any thoughts on that, or we just forge ahead and try and get there? Yeah. Okay. I'd look to finish it between 5 and 5:30 in the evening, as long as I'm in front of a telly for 7 o'clock, that's fine. I anticipate a break for lunch about 1 o'clock, short breaks during the morning and afternoon. Looking to the advocates, obviously, to find suitable timings to stop. Today, it may mean that Ms. Gore has to go away and talk to no one, because she might be in the middle of cross-examination. We'll see what we can do, but that's how it could pan out. Right, in a few moments I will set out what I consider to be the main issues upon which this inquiry should focus. Following this, I will invite opening brief statements on behalf of the appellants and the council in that order, and hopefully no more than 15 minutes each. The aim is to set a scene for a clear and concise explanation of where the parties stand. I will then, therefore, well, taking into account previous exchanges of emails between myself and the party, I understand the appellant's preferences for a traditional format, so the council's witnesses will go first. So I will ask the council's advocate to introduce their witnesses to present their evidence. The council's witnesses will be cross-examined by the appellant's advocate. There will then be an opportunity for the council's advocate to re-examine. I may also wish to ask the witness questions. As I've previously said to Mr. Garber, I will let third parties have their say, hopefully fairly early on. Having heard all the evidence, I will ask for closing submissions, with the last word going to the appellants. It will be very helpful to me if I could be given written copies of the closing submissions. I'm happy to stay overnight to get them. Towards the end of the inquiry, there will be a brief discussion about conditions that would be imposed if I were to grant planning permission. This discussion is completely without prejudice, and I emphasise that it does not mean that I have already made up my mind. Such discussions are common to all inquiries and hearings, and such a discussion does not weaken the council's case. I have seen an application for costs. I'm not dreaming, am I? Nope. So at some stage, well, after the inquiry, we will have a discussion on cost. I'm assuming by then I'll have a written rebuttal from the, or written statement from the council. You're looking confused. Okay. To be fair, but okay, so they haven't seen it, Mr. Taylor. Right, but obviously we will need to do that on Thursday. I've already seen the site and the surrounding area yesterday afternoon. Trust me, it was wet. Depending on discussions in this room, I may or may not make a further inspection of the site. We'll play it by ear on Thursday, and if you think an accompanied site visit will be useful, or even another company want to look at specific things, then I'm happy to do so. But we'll play that by ear to an extent. Any questions about the way in which I intend to proceed? Okay, in which case, so hopefully with the timings I've been given, I won't go through them now, we should, with a fair wind, finish by Thursday. Right, main issues. There may be others upon which I wish to hear evidence. My list is not exclusive, and I certainly will look to all the parties to advise me if there are other considerations. However, from my reading of the situation and from the case management conference, and I consider the main issues to be the effect of the proposed development on highway efficiency, highway safety and air quality, and whether or not, given the location of utility services, the proposed access is viable. And I mean that constructionally viable. Are you happy with those with those main issues? Yeah? Okay. In which case, if there's nothing else, Mr. Taylor.
Can I just make a comment about the technology?
Please do.
I was instructed that we basically, your microphone will always be on, sir, so it's rather like it, apparently with the planning committee, the chairman's microphone is always available. There is then only one available to the rest of us, so when we're asking questions, obviously we need to turn our mic off when the person wants to respond. And of course the importance of it, since this is being broadcast, is to try and use the microphones, because that's where we know things are picked up. And there's one quirk about the various things that we have. There's a left and a right button, and that depends on where you're sitting in relationship to this particular piece of kit, because it does either pick up from the left or pick up from the right. So that's just something to be aware of. Otherwise, hopefully this will work, but it is a bit of a relay in the way it works.
Okay, it's not unusual to have this sort of pressing and not pressing and all the rest of it, but I can leave mine on and it doesn't interfere, is that right? Okay, well I'll probably turn it off when I'm not, simply so you can't hear me coughing and spluttering. So, right, if there's nothing else, Mr. Taylor.
So there is just one matter, if I may. You'll be aware that there have been discussions and negotiations regarding a planning obligation over the past few months, in fact. We've got to a position where I think my instructions are that effectively everything is agreed bar one dispute over one contribution, where the parties have crystallised the amount of the contribution that they seek. A draft has been produced which effectively enables both of those numbers to be put into the obligation with a blue pencil clause, so that you can determine in your decision, should you decide to grant planning permission, which of the two alternate contributions is necessary to make the scheme acceptable in planning terms. We had understood that approach would be acceptable to the councils. However, we were informed, I think yesterday, that Essex County Council does not want to sign an obligation on that basis. Now, it may be that their positions got garbled in translation, but if that is the position, that they're refusing to sign on a basis that enables that issue to be resolved on a bilateral basis, then we need to be told why that's reasonable, and indeed we'll need to be given time if we have to produce a unilateral.
Yeah, fair enough.
But at the moment we're a bit in the dark on this side of the room as to where we've got to with Essex on that matter.
Thank you, Mr. Taylor. Mr. Upton, could the parties sort of get together, heads together and sort that out?
Can I suppose just, as you would have anticipated, it's a sort of three-way agreement, so that there are the obligations regarding the Borough Council's interests are not being in dispute, and that's simple. It's the ones with the County Council where they've been put in the alternative that has caused slight problems, but a lot of progress has been made in discussion. So my learned friend's right that it's just down to the one item that's now outstanding. And I think what had been left open from the County Council's point of view was if in the course of the inquiry further progress was made, then that could be reflected in the agreement. If this is the only if we've got as far as we can as of this morning, and I suppose the two options, the sum is put, it's either something in the order of 7,500 or it's one in the order of 450,000. It's that far apart. But there doesn't seem to be anything in between. Now, if that is the case, and there isn't anything in between, then we have a wording that I think can be signed. If in the course of the inquiry there is going to be any movement on that, then of course that drafting is still not settled. I think that's essentially where I think we've got to. I'm partly looking to the County Council to confirm. So that I think is the one outstanding query from our side. Otherwise there would be an agreement and with the wording settled. And as you've suggested, it would just take a little time to get it sorted in terms of signing. But as I understand it, it's this point about whether or not there is any further scope for discussion on the two opposite extremes, or if that's it. I mean, that's I think is where things have got to. So I'm partly batting it back to my learned friend for clarification.
Thank you. If that's the reason that they want further discussion, then we'll continue those discussions outside of the inquiry. My instructions were that there was a problem with the principle of signing a 106 with the blue pencil clause approach, but it seems like that's not the case. So we'll take it up outside of the inquiry.
Okay, thank you. So, if there's nothing else, Mr. Taylor, opening submissions, please.
Just whilst that's being circulated, would you like a copy of the latest version of the 106 so you can at least see where things have got to, or do you want to wait? We have a hard copy.
Yeah, please, it would be useful. I've got nothing else to do tonight, so... Can I suggest, they're so far apart, the parties sit down with a few pints in front of the telly tonight, and by the end of the match, I'm sure they'll be quite close to an agreement.
The part that's still in dispute, sir,
Yeah,
is this
is.
part at the very, very end that is struck through.
Okay,
the
that's
only
great.
part that's still being discussed. The rest of it
Okay,
has
that's
been
brilliant.
agreed.
Okay, thank you.
Thank you. I've tried to keep these opening submissions very short indeed. As you already explained, this is an appeal against the refusal of planning permission by Brentwood Borough Council for the construction of a new discount food store and 46 apartments on the site of the Wates Way industrial estate on the 23rd of December of last year. I've set out the reasons for refusal identified by the committee, which you will be familiar with. I won't read those out. The appeal site is a disused industrial estate located at the northern entry point into Brentwood town centre. The site has access and egress points onto Ongar Road and Burland Road. It's some 0.98 hectares in size and is currently occupied by 5 commercial buildings forming 3 blocks, which are widely distributed throughout the site. The site is predominantly covered in hard standing, with mature trees located along a portion of the eastern boundary and Ongar Road, which are covered by a TPO. And the site has been the subject of antisocial behaviour and vandalism in recent years and has a somewhat derelict appearance. The northern tip of the appeal site is located on the corner of Ongar Road and Burland Road. Ongar Road is a route into the town centre characterised by a mix of commercial and residential uses. Burland Road is characterised by residential dwellings. Rear amenity space and residential dwellings forming part of Brentwood Place are located to the east of the site. The appeal site is a brownfield previously developed site within the central Brentwood growth corridor as defined in the adopted local development plan. The site became vacant in 2014 and was subsequently acquired by Lidl. The potential for redevelopment of this site was informed by the evidence base of the local plan, which justified its allocation within the local plan for a mixed-use development, including residential. Within the LDP strategic policy PCO3, retail and commercial leisure, explains that in order to meet identified retail floor space needs as set out in policy MGO1, retail floor space will be provided on a number of sites, including that at Wates Way Industrial Estate. The paragraph 7.39 of the LDP explains there's a requirement for 2,286 square metres gross of food and drink, pubs, bars, restaurants and takeaway floor space, and 1,196 square metres gross of other non-retail, including commercial leisure services up to 2033, primarily concentrated in Brentwood Town Centre and in new centres proposed at West Horndon and Dunton Hills, and the appeal site is identified as meeting needs in paragraph 740. The allocation policy, R15 itself, explains that Wates Way Industrial Estate is allocated for residential-led mixed-use development and that the development should provide around 46 new homes and retail, commercial and leisure floor space sufficient to meet the needs of the new community. In terms of development principles, the policy provides that proposals should provide vehicular access via Ongar Road, provide public open space, provide good pedestrian and cycle connection to routes identified in the Brentwood Cycle Action Plan or other relevant evidence, and consider the historic context of the area. At paragraph 9.151, the LDP explains that the development of the appeal site will take its main vehicular access from Ongar Road. It will be expected to adequately mitigate its likely impacts on the performance of the local and strategic road network. During the examination, the local planning authority entered into a statement of common ground with the appellant, including the agreement that the parties agree that the amount and type of development specified in policy R15 can be delivered within the extent of the site allocation boundary as per the content of another hearing statement. Little GB agrees that the site R15 Wates Way Industrial Estate Brentwood is deliverable. There are no overriding issues and constraints to bringing forward these development sites in accordance with the Brentwood local plan. Thus, Brentwood Council, in allocating the site, satisfied itself that a mixed-use development of the scale proposed in the appeal proposals could be delivered via an access onto Ongar Road. Further, the examination inspector must be taken to have agreed with that. In the statement of common ground between Essex County Council and the local planning authority at the examination, the County Council is not recorded as objecting to the allocation of the appeal site for a mixed use, including retail with access via Ongar Road on highway grounds. ECC sought some minor amendments to policy R15, but it's not recorded as having contended that access to the site for the scale of the development being contemplated in order to meet retail needs was not deliverable. It will be argued that the delivery of the appeal scheme entirely accords with the objectives of policy R15 and will deliver housing and retail floor space which is needed on a site which was allocated because such development on this site was accepted to be appropriate and deliverable. Turning to the MPPF test, paragraph, I should say 111 of the MPPF is clear in its terms. Development should only be prevented or refused on highway grounds if there would be an unacceptable impact on highway safety or the residual cumulative impacts on the road network would be severe. The appellant will contend that the proposed development will not have any unacceptable impact upon highway safety. Further, it will not have any residual cumulative impacts on the road network, which will be severe. There has been a considerable amount of highway modelling undertaken on behalf of the appellant and by Stantec, who were commissioned by the local planning authority to produce vision modelling for the purposes of a mediation which occurred. Essex County Council has produced no highway modelling itself. The appellant believes that Ms Gore, in her evidence, has misunderstood the basis on which Mr Budd produced his further vision modelling of scenarios based upon an assumption of 30% new trips and 70% pass-by trips. It is thought that this is because she may have failed to open or understand an Excel spreadsheet provided to her by Mr Budd. There are a number of other issues we shall explore. The likely traffic generation from the site. The appellant intends to explore the extent of the likely traffic generation within the context of the network as a whole. It will question the extent to which it's realistic to conclude that relatively small changes in traffic generation will give rise to impacts which can be described as severe. Whether the site access signalised junction requires 4 stages or not for highway safety reasons. The appellant will contend that it does not. Whether there is sufficient capacity within the site access junction to accommodate demand from those turning right into the little store. The appellant will contend that the LINSIG and VISIM modelling demonstrates that sufficient capacity is provided and will point to the road safety audits undertaken in this regard. Whether an assumption that 70% of the trips to the proposed new foot store will be new trips to the network adopted by Stantec at the behest of ECC is justified. The appellant will contend that such an assumption is not in this town centre location. The appellant intends to explore with Ms Gore the extent to which ECC has adduced evidence to demonstrate that it is appropriate to adopt an assumption that 70% of trips to the store will be new trips to the network. The appellant will contend that there is no evidence to justify such an assumption, rather an assumption of around 30% of trips to the store being new trips to the network should be adopted. The appellant, of course, recognises that introducing a signalised junction at the site access where there is not one at present will introduce some delays to journeys, but that is the case whenever a new signalised junction is created. There is nothing special about the proposed junction which means its impacts can be described as severe. The appellant will contend that even adopting the highly robust assumptions that were adopted in the Stantec modelling, the appeal scheme does not give rise to impacts on the road network which can be described as severe. Indeed, once more appropriate and realistic assumptions are adopted, the degree of impact is such that it's unlikely to be noticeable other than at the new signalised site access. Indeed, the appellant will question whether the Council's refusal of planning permission in the present case can be described as reasonable. In terms of highway safety, the appellant will contend that the proposed development will not give rise to any unacceptable impacts on highway safety. To that end, we intend to explore the implications of the Taylor-Bowie Stage 2 safety audit, which has been commissioned by the appellant with Mr Henderson. Mr Henderson raises a number of safety issues which, for the most part, are not well founded and have not been identified in other road safety audits. The Stage 2 audit commissioned by the appellant will be explored with him, and where he's raised issues that need addressing, Mr Budd will explain how these have been or will be addressed as the scheme comes forward. In terms of air quality considerations, the appellant will contend that there is no basis for concluding that the proposed development will have any unacceptable air quality impacts. The appellant will argue that the proposed development will not give rise to, nor will it exacerbate, any breach of air quality standards or objectives. The appellant will contend that refusal of permission by reference to air quality considerations was not reasonable. In terms of deliverability, the Council's refused planning permission on the basis that it has not been demonstrated that the signals at the site access can be physically accommodated given the presence of statutory undertakers apparatus. The appellant will contend that refusal on this basis was not reasonable. The conditions, as you will have seen, are essentially agreed. In relation to the planning obligation, there remains one outstanding item relating to the amount of a contribution which the appellant would like the opportunity to explore. Whether the appellant's view is accepted or the Council's, the planning obligation allows you to determine which is necessary to make the development acceptable in planning terms, and thus it's not an issue which affects whether or not planning permission should be granted. To conclude, the appellant considers that its application has not been appraised properly or appropriately by ECC. It intends to explore the extent to which ECC and the local planning authority, in reliance upon ECC, have adopted the approach required by the MPPF at paragraph 38. Thus, we intend to explore whether the Council's approached the decision on the proposed development in a positive and creative way, whether they have worked proactively with the applicants to secure a development that will improve the economic, social and environmental conditions of the area, and whether they have sought to approve the application where possible. The appellant contends that the refusal of the proposed development of the type contemplated by the allocation in the recently adopted local plan was not reasonably founded, and the appellant will contend that the proposed development accords with the development plan and the MPPF, and as such it will be argued that planning permission must be granted since there are no material considerations indicating that permission should be refused. Thank you, sir.
Thank you, Mr Taylor. Mr Upton. Just before you start, there's a gentleman standing up there. He looks very lonely. Is there any reason he can't come and sit down here? Sir, if you want to come and sit at the back down here, feel free. Okay? Right, sorry about that, Mr. Upton. Thanks.
I'm also going to be... sorry. Yes, there we go. I'm also going to be short in opening. Obviously, at this stage, it's quite easy to reduce it to writing before anticipates what happens. But I did want to sketch out exactly where we are, and so also local residents know the limit of what we will be arguing. As I say in my opening, this is one of those inquiries where the main controversies are about what we might call the nuts and bolts of planning. The appellant proposes to construct a new access junction. There is a significant dispute about whether it will work safely and about the effects on the performance of the local highway network that the introduction of this new junction would have. And of course, the proofs of evidence therefore concentrate on the reasons for refusal. But like all planning inquiries, there are a large number of potential issues. The ultimate decision is still about whether planning permission should be granted for this development and with what planning conditions and related planning obligations and contributions. We are aware that there's been a fair amount of local interest, and a number of local residents have indicated they wish to address the inquiry or indeed have written in. So it is worth confirming that, in principle, the Borough Council agrees that the redevelopment of this brownfield urban site for a mixed-use residential and retail scheme would be in accordance with the local plan. Indeed, the additional convenience retail floor space provided by the proposed little food store would make a positive contribution to the local economy and to Brentwood Town Centre. The design of the scheme would provide an active street frontage and it would enhance the Brentwood townscape. The additional 46 dwellings would contribute to the supply of housing. Now, all of this is covered in the statement of common ground agreed between the main parties. The statement of common ground is particularly important in this case as it covers so many of the issues that would normally be in dispute. And of course, the proofs of evidence from the planning witnesses in this inquiry are unusually uncontroversial as a result. And you have, obviously, from us, Ms. Katie Parsons' evidence that deals with planning issues on behalf of the Borough Council. So as regards local residents, the Borough Council was aware of the concerns raised by local residents in their representations, and they were discussed in the officer's report to the committee, and the planning conditions have been drafted with them in mind as well. But in terms of the Borough Council, the stumbling block has been the details of the highway proposals needed to meet the necessary development management criteria. This is not a case where, in the overall planning balance, the benefits of the development can outweigh the concerns identified about the highways and transport issues. It's not being said by the appellant that they would do so. The dispute is whether those concerns identified in the reasons for refusal are made out. And in a sense to say, that's a simple question. It doesn't have a simple answer, of course. You will hear from the Highway Authority witnesses about those reasons for refusal. Mr. Ian Henderson deals with the road safety issues. Mrs. Hilary Gore deals with the implications of those and the wider highways and transport issues. And I would summarise the County Council's concerns as being that from the beginning, the highway consultants for Lidl, SCP, have been trying to do too much in too confined a space on a congested part of the local network. We can admire the persistence of SCP, who are trying to fit a junction to fit what they've been told their client needs. The history of the consideration of the new access started before the submission of the planning application in August 2020, which is the one we're looking at, because the first pre-app was in 2014, and there was an application in 2019-20 with the same access, which was as an application then withdrawn. And there's also been a commendable attempt to mediate the issue that looked wider than just at the application before the local planning authority, as that process can do. Now, there are some broad areas of agreement about which models to use and which area of the local network needs to be considered. But there are still significant differences about trip types and distribution and about capacity. It appears that it is agreed but what the effect of the different scenarios that have been modelled would be, but not what the relevant scenarios are that should be used, or the standards against which their results should be judged. And of course it's important to get this right, as the site's access is onto the A128, called the Ongar Road in this instance, which is recognised as a main artery for movement and is close to some significant junctions in the town centre. The importance of the routes that would experience increased delays is as important as the scale of the delays that have been identified. Of course, that's discussed in the evidence. The road safety audits have revealed unresolved safety problems about the design and layout and proposed signal staging. There is also a reason for refusal relating to the ability to construct this proposed new signalised junction and what, if any, pre-commencement planning condition can be imposed. The advice from the Highway Authority on that is that it considers that the evidence available is still inadequate and that it has still not been satisfactorily demonstrated that the necessary signal equipment can be installed due to the presence of key statutory undertakers' equipment, which may be too difficult or too costly or both to relocate. And then just dealing briefly with this point about air quality, there's also a reason for refusal relating to the increased impact on local air quality from traffic. The underlying evidence was presented in a written report back at the time of the planning application and reviewed. That report was updated in the RSK report, I think just now before the inquiry is the main one, submitted with the appeal documents. And I do understand that the air quality witness from the appellant adds new evidence to that. And I do say this is a planning policy point regarding the individual and cumulative impact of new development identified in the local plan. And ultimately, we do accept that the proposed transport contributions, if they are forthcoming, would address this. And as you've heard, there's been further discussion regarding the planning obligations and the highway contributions that would be necessary. And that discussion is in addition to the SIL compliance statement that you've got in writing. And so it does appear that all the items bar one are agreed, though it's all about the sums involved that remain the standing issue. And of course, it's not just on that one issue where there is the difference. There is the difference on a number of other transport contributions as well, which you'll see in the agreement. They're written in the alternative, depending upon your determination. And the areas of agreement and disagreement were summarised, as you will hopefully recall, in an appendix to the Statement of Common Ground. And that, of course, forms the basis of further discussion. So that's all I wanted to say in opening, just to sketch out where matters now stand, and also obviously to highlight how much we are focusing on one part of a much wider planning application.
Thank you, Mr. Upton. Right, as I suggested earlier, before we ask for your first witness, would Mr. Garbett like to say a few words? And if you could let us have, I see you've got photocopies, thank you to the council for that. Okay, thank you.
I'm going to talk to.
Yeah, okay, I'll make any notes on it I need to.
Just checking on copies as the first
Oh,
bit.
sorry, you haven't got copies?
We haven't got copies.
Oh, sorry, no. We're never doing copies. Both parties need one. How long will it take, or are you happy to have one post? Okay. Okay.
Sounds like we should get a copy, but we can proceed for the moment.
Well, if you can get a copy afterwards, if you can, yeah, okay. Mr. Garbett, over to you.
Okay, because I'm smack in the middle. Okay, well, okay, well, hopefully you can hear me. I do apologise. I've never given evidence at one of these things before or spoken before. Like a lot of residents, I'm passionate about what's going on. My name is Frank Garbett and I live at 157 Ongar Road, which is approximately 300 yards north of the proposed development. It's actually the junction of the Doddinghurst Road and the Ongar Road. And Mr. Wilde may have experienced when he went down to the site may have seen the Ongar Road in several conditions, one of which is particularly prevalent, and that is during the rush hours and the school goings and comings time, the Ongar Road is completely gridlocked. From my point of view, it's fabulous because I can get out onto this busy thoroughfare without actually having to get in the way of cars whizzing up and down. But I also used to be a caretaker at the school, one of the schools in Sawyers Hall Lane, and parent after parent used to complain about the delays on the Ongar Road, which have grown and grown and grown. Since 2014, when Lidl acquired the site, it's got worse and worse, and people will report repeatedly that it takes them between 20 and 30 minutes to go half a mile. So any development on the Ongar Road is likely to affect, and where Lidl are proposing to build in Wates Way cannot do anything else than make it worse. I was one of over 120 people who objected to the original development. I think apathy may have reduced the number of people who have lodged objections to the revised scheme. And as I said earlier on, the notice for the inquiry was a little unclear as to whether people could attend and whether they could voice their opinions. The vast majority of people that I've spoken to and met all welcome Lidl being a competitor in Brentwood to offer competition to Sainsbury's and other supermarkets. There's absolutely no problem about that. And we all recognise that properties have got to be built somewhere, and a mixed development which has been proposed has no real great objections from the majority of residents. It's got to be in keeping, it's got to be right, and we rely on the planning authorities and the planning regulations for the mix of whatever's going to be done. No problem with that. But the main objection is the traffic, the problems we've got with the delays and the safety, and there are thousands, well, I was going to say there probably are thousands of children who walk along Burland Road and Ongar Road every day, forwards and backwards, and some of those children are aged 4 and younger with the parents. It's crowded, it's congested, it's difficult. So that is a problem. And the air quality, again, which you've picked up as a major consideration, in the original plan, and I can't say that I've read the revised plan in terms of the air quality measure, there were serious concerns raised by several of the local residents who've got expertise in this area that the actual original measurement was not done in the pertinent places where there are hold-ups and where they will be, where Lidl's exit and entry will be. They were done, for example, at the top of Sawyers Hall Lane, where it crosses with the Chelmsford Road, rather than being at Wilson's Corner, which is a notorious and known bottleneck. And as I say, I can't speak, but it's a technical point which I think you guys are all going to cover, and I wouldn't understand what it is, but hopefully making it worse is not on the agenda. The Wates Way site is an eyesore and has been more and more a health hazard, and an appropriate development of the Wates Way site would, in my opinion, and the vast majority of people I've spoken to, would be welcomed by the majority of people who live in and around Brentwood. But the objections to the store being built in the way that's proposed and with the traffic access that's proposed is something that nobody approves of. That's all I've got to say. I wish
Thank you, Mr. Garbutt. Mr. Taylor, any questions?
Sarah, thank you very much.
Okay. Thank you, Mr. Garbutt. Mr. Upton, your first witness, please.
Thank you. Proposing to have Mr Henderson as the first witness. It may take a little bit of setting up to make sure he's got the right documents and access to everything, but hopefully this will work. I'll take it reasonably slowly, but hopefully it's online, certainly. There was a summary proof that we were going to use as the text. Now, Mr Henderson, I hope you've got your summary proof. There's also a rebuttal you prepared in response to some points raised by Mr Budd. Hopefully there's two documents to hand, and if we do need to go into the documents, just if you give us a reference, obviously we can hopefully all land up in the same place. But can I introduce you to the inquiry and then ask you to turn to your summary? And you're Mr Ian Henderson, and your formal title is Team Leader for the Road Safety Engineering Department for Essex County Council. But I think, as you pointed out, you're formally employed by Ringway Jacobs, even though your role is to do that specific task. Is that right?
This is, yes. So I work on behalf of Ringway Jacobs. And our main client is Essex County Council, the Highway Authority.
And then, as you also summarise in your proof, but here it's in your summary as well, that you have over 20 years' experience in the field of road safety and have acted as a practicing auditor for the last 14 years and conducted some 500 or so road safety audits. And I should say that's essentially for the County Council, or do you work outside as well?
In the last 10 years, it's been mainly for Essex County Council. We do some cross-contract work, so that's across the country for other Ringway Jacobs authorities as well. In a previous life, we were Atkins International Highways, and we were across the actual country as well. So the last 10 years, it has been mainly ECC and Essex Highways I've been working for.
Explain your role with regard to other people's work as well. Can I ask you perhaps to pick up at 1.4? I should say it's still first planning inquiry, but you've done court work. Is that a fair summary? Yeah. So it's the first time you've done a planning inquiry itself, but you're familiar with court procedure. I just want to, people start assuming things of you that they know where you're.
Yes, this is the first planning inquiry I've attended, but I have been witness at Coroner's Court as well, so I have to attend that as part of my fatal investigation process for Essex County Council and Essex Highways. So similar court proceedings, but not exactly the same as planning appeal.
It'll go smoothly. I'm hoping that for the most part I can leave my microphone off, but we will just pick up a couple of things as you go through your summary. Could you pick it up at 1.4, please? And read from there. I know you've given us a challenge.
This summary of my proof of evidence deals with the highways evidence relating to the third reason for refusal. From a highways and transportation perspective, the impact of proposals is not acceptable to ECC on safety grounds. Continue. On the 18th of November 2021, the Essex Highways Road Safety Engineering team received a commission from Brendan Johnson, ECC Strategic Development Engineer, to undertake a road safety audit in relation to planning application 2001221 FUL. An RSA membership team of myself, Adrian Carden, who is the RSA team member, and Jasmine Wiles, who was our RSA observer, was selected to undertake the site investigation. A site investigation was undertaken by all three members of the RSA team on the morning of Wednesday, the 24th of November 2021. The Stage 1 RSA reference 8732 core document J1 was issued back to the overseeing organisation, Brendan Johnson, on the 20th of November 2021. The Stage 2 RSA detailed design drawings, core document J6, were also provided by ECC on the 9th of August 2022. These were reviewed separately by myself in order to identify if the previous problems raised in RSA Ref 8732 have subsequently been resolved. The items that follow are those which are still deemed outstanding and are of a level of safety concern that they require addressing and resolution at this stage in the design process. They cannot safely be left to be addressed later. Parking issues outside number 76 and road users exiting and egressing from New North House. The overrunning of curb edges due to insufficient stacking space for road users turning right into the development access. Articulated goods vehicles entering and exiting the new access colliding with stationary road users waiting to turn right. The new Little Access Road and North Road running in the same signal stage and resulting in road users turning into the path of other road users exiting at the same time. Insufficient room for articulated goods vehicles to pass a stationary bus when travelling north of the junction. The junction type being considered for this location due to the signal installation increasing congestion in the development area. Insufficient length of the north-westbound right turn lane providing stacking capacity for road users waiting to turn right into the new Little Access. Articulated goods vehicles exiting the Little Access to turn left, entering the opposite traffic lane, where road users are waiting to turn right into the new access and overrunning the northbound signal stop line. Insufficient length of the southeastbound right turn lane, providing stacking capacity for road users waiting to turn right into North Road.
Can I just pause there? Just see if this works. There's obviously been a comment in response by Mr. Budd about whether there's some overlap between these issues. Could we just be clear about how they, I suppose, have firstly arisen and where they're covered? I see your paragraphs in the summary are 111 through to 119, but actually one could just take the last number. 11 through to 15, or essentially the first 5, they're from the RSA 8732, aren't they? That the items identified in your section 8. And then the remaining 4 from the early RSA 8284.
Yes.
Yeah.
As part of the RSA process, we will go back and review previous RSAs. In this case, we reviewed RSA 8824 and I believe the JHB consulting RSA as well.
Okay. Perhaps it'd just be helpful to turn to the document 8732 because I wanted to just ask you because there's been a point made about an overlap. Now, hopefully in section J are all the road safety audits. And hopefully the first of those, which would be J1, would come up as the Yep. And then hopefully you'll see there in the box on the title page is the registration code 8732, which I suppose I've been using as shorthand. But yeah. Now within this document, if we go through to the sections, I suppose one can see the drawings and documents provided that you've considered include obviously the relevant drawings, but also previous RSA work carried out and the transport assessment. That's 1.10. And I was just setting out the document, and I'll ask you the follow-on. The section 4, items raised during the previous stage 1 RSA, that's the reference one with 8284, isn't it? Go slow. So that's JHP Consulting. And then section 5, section 6, yeah. Yeah. And hopefully, I want to make sure I got this right, when you give problems a number, they've maintained the same number throughout this process. So, for instance, problem 6.2, which is from 8284, you've kept the same numbering in this report, 8732. Yeah. And then the new problems, the ones I suppose the first 5, are in your section 8, is that? That's correct. Yeah, okay. And I suppose it may just assist as in this. Problem 6.2 was your 6th in this list in your summary. Problem 6.3 was the 7th in your list. And 6.4 is the 8th, and the last one is 6.5, which essentially you've identified as being outstanding. Yes, that's correct. Yeah, okay. And then obviously we go to the section 8. I just thought it helps to put that in context. So if you need to, obviously please refer back to this, but the list in your summary, or indeed in your appendix, sort of points being made that there seems to be some duplication or overlap. Could you just explain why they're still identified as separate points?
So in terms of the actual whether or not there's duplication, it's more the description of the problem itself. So when we describe the north and southbound approach lanes as such, one of the problems we've written, saying there's insufficient capacity for road users to turn right, it's applicable to both stages, to turn right into North Road and then to turn right into the Lidl access as well as part of that.
Sufficient for the moment. I mean, it's because one could do a very quick reading, see it as the same point. But, yeah, okay. Do you want to then return? We put the well, we've got electronic documents on, so I'll go back to your summary because you then deal with other points that have arisen, and it's probably worth just covering that before we then just touch on what your rebuttal covers.
The items that follow that are outstanding but which we consider can be addressed and resolved at a later stage within the detailed design stage. Improvements to the skidding resistance of the junction, signing improvements for road users travelling north-eastbound from North Road towards the Lidl access in terms of guidance to the left of the central island, measures to prevent discouraged road users from queuing over the crossing carpets of non-motorised user crossing areas, the tactile paving present on the south side of North Road crossing area, measures to determine non-motorised users travelling northwest past number 71 from stepping off of a full height curb excuse me, to access the central refuge waiting area, improvements to the lane destination signing and carriageway markings along the southbound and westbound approaches to the junction, provisions of a maintenance bay for traffic signals engineers servicing the site, measures to further deter delivery drivers who currently ignore the no waiting or no loading at any time restrictions present to the south of the junction, removal of vegetation as part of the visibility display requirements for improvements along Burland Road, footway gradient and curb upstand information relating, in relation to the controlled and uncontrolled crossing areas as part of the new junction proposals, inconsistencies with the tactile paving arrangement provided as part of the central refuge provision along the northern and eastern arms of the junction, tactile paving and drop curb information in relation to the proposed non-motorised user crossing facilities along William Hunter Way, provision of signing and road markings in relation to road users accessing Burland Road and entering the one-way system, provision of parking only to be allowed outside properties where an existing vehicle access drop curb is already provided.
Thank you. Now, I suppose it's perhaps just worth picking up for those who aren't aware, I suppose, why you're happy for these, having identified the problems, but happy that they could be resolved. There's been mention of some stage 2 drawings being available at this stage. I suppose let's start with the first point. How would you normally expect this design work to be done? At what point would these detailed points be resolved?
So typically you'd go through the stage 1 process and you would try and sign off all the problems. These are more detailed design issues, so where you get more to the physical building of the site itself in the finer details as such. You would typically expect a package of measures or package of drawings to come through for an RSA2, which would show you your tactile paving, which would show you the signing and lining drawings, which would show you your drainage and your skid resistance, which would show you where your maintenance bay would be, additional measures to deter delivery drivers as such. That's all the sort of the nitty-gritty you would expect at a stage 2 detailed design.
Before something is built, is there any other stage, or is it stage 2 is what's approved and should be built?
Basically, stage 2 is the plans in front of you to be able to build it. So when we have a stage 2, and we do this for a lot of development management and strategic schemes that have passed through the process, the drawings we expect in front of us is what's going to be physically constructed. So you could hand them to a clerk of works or anything, and they can get on and actually physically build it. So it has to be that level of detail. Quite often we push back with various developers if we haven't had a sufficient amount of detail provided to us at stage 2, because we can't audit it in that detail. We need to physically be able to see what's going to physically go into the ground itself.
Can I interject there, Mr. Upton? I'm sorry, just for clarification, and I'll be doing this a bit because it's a technical one. Can you just remind me, stage...
It's pre-planning application. Yeah.
Stage 2?
Detailed design. Stage 3 is the post-construction. There can be interim audits commissioned by the client or the overseeing organisation, and that can be done as many as they see fit. Typically, we have an interim stage 3, which is just before opening, so they like us to go out, and it's normally picking up snagging issues and things like that. Whilst the contractors are still on site, it allows them the opportunity to remedy problems before it physically opens to the members of the public.
Okay, thank you. Sorry, Mr. Upton, back to you.
I'm glad to, because obviously we have a mix of such stages before the inspector. But so I suppose at the stage of a sort of planning approval, it essentially normally be stage 1. I don't think that's disputed. But yeah, okay. Now you then go on in your summary to mention points that are outstanding following a review of what was put forward as detailed design drawings. I suppose just to clarify, the detailed design drawings that have been produced have addressed most of the points you've identified so far as being capable of being addressed at the detailed design stage. Is that a fair? I suppose in your summary you had a list of 121 through to 134 of things that you would expect to see in the detailed drawings. Is that what's happened here?
We would expect all the problems previously listed to have been signed off and resolved before you present a detailed design in front of you. So all those problems I've previously listed that should be resolved at detailed design, I would want to see evidence of that presented to me in terms of sign off before actual detailed design is signed off.
Pick up your 135. That's a sort of another sort of category.
Okay. The items that follow are outstanding following a review of the detailed design drawings provided. These will require resolution prior to the finalisation of the detailed design process. So we've got inconsistencies between the traffic signals drawing and the general arrangement drawing in terms of secondary signal pole arrangements and the tactile paving in the central refuges. signal poles 8, 9, 13 and 14 to be provided with adequate carriageway clearance, provision of proposed signing as part of the refuge islands arrangements, lane destination signing and temporary new road layout ahead signing, and inconsistency between the traffic signals drawing and the street lighting drawing in terms of the positioning of a lamp column adjacent to signal pole 4. So we'd expect to see on that.
I know you've picked up some further points in the rebuttal, but do your conclusions remain the same? In which case we can deal with conclusions and then just check off the rebuttal. But
Yes, they do, yes. To conclude, there are still a number of safety-related problems that need to be resolved through the design process. There's also a number of selected problems which subsequently can be addressed at the later detailed design process.
and there's a little just bit over the page.
However, the fundamental issue is that there still remains a number of unresolved problems which pose a high level of safety concern and in turn require resolution at this stage in the design process. It's therefore concluded that currently the scheme proposals present an unacceptable level of impact on highway safety and that the refusal on these grounds should be upheld accordingly.
Clarify how that fits into the evidence. We need an electronic reference. Has it been added as an electronic document? I've got an old copy. Is it online? Or there will be a physical copy, won't there?
3.3.2.
Let's see if this works. F3.3.2 should take you to the rebuttal.
Or F515.
Heading 515, yes, that's the one.
Now, hopefully, that produces a document in landscape format. And so hopefully we've all got the same document. And headed updated appendix IH1. There's some very short text on the front before you go into what the revised table is, and that, as you point out, this has been produced in response to what was called the designer's response to your road safety audit 8732, and that you hadn't seen before. So you've, I think as you say, this is your opinion. It hasn't gone through the RSA team, and perhaps I should just pause there. What's the significance of that? What is the role of the RSA team? Why can't you just sign it off on your own?
So as part of the RSA process, it's a team membership. You have a team leader and a team member of part of the core membership of the document. As part of the designer's response process, both of those team members who collated, who signed off the actual RSA report will do a subsequent review of the designer's response. And that's more to facilitate discussions of the designer's response. Do we think this is right? Do we accept this? And it's not just one core person doing that itself. So I did the initial review as that. The process would be for both the audit team to sit down and review the designer's response and then provide their actual response to that as well.
And then if we go to the table that you've now produced, I suppose the main difference is the addition of a further column, isn't it, at the end? The in Henderson review of Jim Budd, proof of evidence, designer's response, October 2022. Is the rest of the text in the rest of the table the same? It's that final column that's new.
Yes, it's only the final column that was added in, as well as the designer's response element in the middle. So the designer's response provided as part of the Jim Budd proof of evidence, and then it's my review, which is the final column on the right-hand side.
Thank you. So just really to establish how it goes, so just taking, for instance, the first item, what you had referred to as problem 8.2 in the original road safety audit A732, which is all about the skid resistant surface, initially you had said that was an outstanding problem, but it could be addressed in the detailed design stage, and we now have, I suppose, the detailed design response. And your comment, can you just clarify at the end what you've said about that particular problem now? And then again, just I suppose just consider 8.3, which is about this issue about road users outside number 76 and New North House, and it's was identified, as in your summary, as an outstanding problem requiring resolution at this stage. Just obviously there was a response in Mr. Budd's proof that that point's not accepted, and where do you stand on it now? And obviously it then works its way through, and as you said, your conclusions remain the same. So, so if I could take this very quickly, that where previously this appendix IH1 had identified outstanding problems which can be addressed at the detailed design stage, that conclusion essentially still continues. Yes. And where it says outstanding problems which require resolution at this stage, that conclusion remains, despite what you've now seen. Okay, I think so. I wasn't proposing to go through the rest of the appendix unless that was helpful at this stage. No, right. Then I think we can put that back to one side. I suppose just to confirm that that's the appendix that deals with the problems in the sort of chapter 8, if I can use that broad term. But I think as you identified, there are still some outstanding problems from what was chapter 6, if I can use that broad term, which you had summarised in your summary, and we've already identified where those are. Unless there's anything else you want to add, does that deal with the points from your point of view? Thank you very much. That's what I wanted to ask you this time.
Okay, thank you, Mr. Upton. I would suggest that that's quite a good time to break. Say back here at 25 to, is that all right? Just over 10 minutes. And also a very good time, I would have thought, for someone to get me the biggest drawing of that junction we can get. So I can understand when we're talking about houses, when we're talking whatever, I know, because it's not actually useful doing it on A4, trust me. So if we could get that during the break back here at 11:35, that would be great. Thank you. Sorry?
Am I of any help?
Ah, now we're talking.
So they're my ones that I do my safety.
Music to my ears, thank you. Sorry? Okay, no problem. Mr. Taylor, what documents are we likely to need for cross-examination?
So you're just going to need Mr. Budd's proof and rebuttal, and Mr. Henderson's proof and rebuttal. I hope. That's
More music to my ears. I apologise for the wait. They're doing it for me, so I really do appreciate it.
No, I think it's really important that we have it.
It's very important, but this is the joys of modern working, I'm afraid. Normally this lot would have been with me, 2 weeks before the inquiry in a box, but what it means is I'm not chopping down trees, but the council.
Thank you.
Thanks, Hazel.
Those, okay.
Right, thank you for that. If everybody's ready, Mr Taylor.
Sir, thank you. Mr Henderson, can I just clarify when you first got involved in looking at the highways proposals associated with the appeal scheme? Am I right that it was on the 18th of November 2021 that you first got involved? When you were asked by Mr Johnston to undertake a stage 1 road safety audit? Yeah. And you explain in your brief that you're a team leader, and the team that looked at the position in November 2021 included Mr Carden and Ms Wiles, is that right? That's correct, yes. Yeah. So you get asked on the 18th of November to do the stage 1 audit. You explain, I think, at 2.5 of your proof that you went out to inspect on the Wednesday the 24th. Yes, the site inspection done, thank you. Well, as weekenders on Wednesday the 24th. Yeah, and then the stage 1 assessment was written up and it was provided back to Brendan Johnson on the 25th of November. Yes, yeah, I ended up getting back from site. There was an urgency from ECC on the 10th of that, so it was quite a late night on the Wednesday and then through the Thursday dedicated and delivery the next day because of the urgency. Yes, because on the 18th of November it was known that the application was going to committee in December, wasn't it? But you accept that your stage 1 safety audit was conducted at speed? It would have been conducted at a normal speed, which I'm writing audit, so right up road safety audit, you're probably looking at 8 to 12 hours approximately in terms of complexity of the audit, the number of problems that were picked up, so not at speed but delivered the next day. Typical turnaround would be 5 to 10 days, depending on how long it takes to write up an audit. Some audits take 2 to 3 hours, some take 8 hours, some take 16 to 32 hours, depending on how many problems you pick up. So having produced your stage 1 safety audit on the 25th of November 2021, how many times did you and your team meet with the appellant's team to discuss road safety considerations relating to the appeal scheme prior to the refusal of the planning permission on the 23rd of December? My team won't have met with the actual appellant in terms of discussing part of the road safety audit is to have a significant sort of Chinese wall in place that we won't engage directly with the developers or designers as such in terms of the information provided itself. Okay. It's a separate, it's meant to be provided separate for a reason, so there's not a blurring of lines. If I suggest to you that nobody from Essex County Council met with the appellant's team to discuss highway safety issues prior to the refusal of planning permission, would you accept that? Okay. And indeed, since the refusal of planning permission, am I right that neither yourself nor any member of your team has met with the appellant's team to discuss road safety matters? Not from my perspective, not from people who conducted the road safety audit, so myself, Jasmine Miles and Anthony Harden. I can't answer the ECC, I'm afraid. Yeah, okay. So ECC were given your road safety audit stage 1 on the 25th of November 2021. They made representations to the local planning authority which were taken into account as part of the refusal process on the 23rd of December. the first time that the appellants were provided with a copy of your report was with the council statement of case. That's right, isn't it?
I believe so.
Yeah. So Essex County Council relied upon a road safety audit that wasn't disclosed to the appellants as the basis for its objection to the appeal scheme without the appellants even seeing it. That's right, isn't it?
I can't comment on the ECC procedures and processes once the audit is submitted to the ECC client, what their internal distribution of government delivery goes over the auditing and such. That's why we keep completely separate as such.
Okay.
Can I just check on the microphone? Because I know clocks and clocks, but it may not be the same.
Can you hear me all right? I can speak up a tiny. I can try and project it a bit more if necessary.
All right, thank you. Now, in terms of the issues as you identify them in your evidence, there are a number of matters that you identify as problems in your proof, and there seem to be different categories of problem. I just want to understand what the implications of that are. You have outstanding problems which require resolution at this design stage. You have outstanding problems which can be addressed at detailed design stage, and I think you've got a sort of third category as well of problems which have been addressed. Is that a fair summary of how you divided?
It's three categories.
Yeah.
The first one, they're the showstoppers. They're the ones that need to be dealt with before planning through the detailed design, sort of the design process. That's where we sort of really down into detail. And obviously there are ones that have been resolved, they're the ones that are good, they're the ones that get approved in the guidance and such.
Right, so just to clarify that then, where we see in your proof a list of points under the heading outstanding problems which can be addressed at the detailed design stage, you're not suggesting, are you, that those issues can legitimately form the basis for a refusal of planning permission?
Sorry, could you repeat the question?
Yeah. Where we see in your proof the heading outstanding problems which can be addressed at detailed design stage. Sorry, what page is that? For example, at 440. Which appears elsewhere. Where we see that heading, you're not suggesting to this inquiry, are you, that the problems which you identify under those sections, which you say can be addressed at the detailed design stage, that those form a legitimate basis for refusal of planning?
I couldn't comment on the actual refusal of planning application. It's more that they can be dealt with at a detailed design stage, so they're problems which can be designed out as such. It would be preferable that they're addressed at this stage because it's a fundamental knock-on effect. You wouldn't look to do a detailed design stage if you haven't addressed one of the previous sort of large showstoppers. It wouldn't make any sense to try and address it at a detailed design stage if you haven't already tried to resolve it at a sort of planning prelim design stage, as the stage one in essence. They should be addressed. It's not that they couldn't, they should be addressed.
My question is sensible. You're not suggesting, are you, that they couldn't be addressed at the detail stage?
No, it's the fact that they should be addressed at pre-planning stage. You can't get to a detailed design stage and ask for fundamental curb alignment, curb changes, the stuff that has to be done in terms of if there's any need to have land take requirements, the fundamental foundations have to be established before you move on to a detailed design stage. It's not that they can't be addressed at the detailed design stage, they need to be addressed at an earlier stage. You wouldn't put the initial foundation down if it's not correct and then start building on it as such.
In respect to the items that you've identified in your proof,
It's not really for the RSA team to come up with solutions as such. We can make recommendations, but it's more for the design organisation to provide the solutions in front of us as such. It's not the audit team's remit to try and identify the actual physical solution. We can make recommendations and then the subsequent design team can begin the design process.
so your evidence that this inquiry is that there might well be solutions to these problems.
If there is, they haven't been presented in the design process for us, the road safety audit currently.
And your evidence to this inquiry is not that you are convinced that there is no solution.
I can't comment on the solution process. We can only audit what's physically put in front of us in terms of the design itself. Part of the standard for road safety audit, you step into the shoes of the designer. If you're saying this could be the solution as such, the actual recommendations have to be written in a way as to not lead the designer into design. In essence, the road safety auditor shouldn't be designing the scheme for the designer through the process.
So, who is it then at ECC? Who's the officer at ECC who is tasked with taking your safety audit and then identifying potential solutions and discussing those with the appellant?
It would be the client, the overseeing organisation, so Hilary Gore or Brendan Johnson in this case, I presume.
Thank you. Right, let's turn to your proof, go to section 4.4. Paragraph 4.4. My version doesn't have page numbers.
Is it 4.40?
4.4 outstanding problems which require resolution of the design stage. Since your section for safety related problems raised as part of Essex Highway RSA 8732 November 2021.
So are we in my proof of evidence or are we in the actual RSA report?
We're in your proof of evidence itself.
And 4.4 outstanding problems which can be addressed at the detailed design stage. Okay.
This is where you start to go through the first category of issues that you've identified. And the first one you describe, 4.6, relates to road users parking outside number 76 and also road users reversing from Newhall's house into the road.
Which number is this? Because my 4.41 doesn't follow on a number 76. Sorry?
It's problematic because there's no page number. Maybe 4 pages in.
Okay, 4.4. Okay.
You've got your section 3 RSA process and scope, and then after that we get into safety related problems raised as part of Essex.
Yes. Okay, yes, fine. Yeah.
And I want to take you to paragraph
Yes, the first outstanding problem. Yes, okay.
And relates to an issue of road users parking outside number 76 and road users reversing from New North House onto North Road. Yeah?
Yes, yeah.
Okay. So, number 76, the issue of 4 seconds described as if road users continue to park outside number 76, they will be obstructing the pedestrian footway, which is proposed to also form part of the crossing location. It means pedestrians making the step into the carriageway to pass any parked vehicle, putting them at an increased risk of collision from a passing road user. So, people parking outside number 76, is that people parking outside?
Sorry to interrupt, Mr. Terry, I hate to do this, but can we identify where 76 is on the map?
Yes. So if we, let's use the map that we've handed out. If we look at Appendix HD 18, which is the one that shows the footway being built out. That's that one, is it? On the yellow. Yeah. Yeah. Number 76 is the building on the corner of Ongar Road and North Road.
Okay.
Just here, is that right?
Yes, if you look at document reference A26 in the paginated file, it's actually got number 76 listed if we need to.
We all know where we are.
Yeah.
Now, the
Obviously, I will, having heard this, I will go back and revisit it, so either on my own or in company, but, thank you, sorry.
not all. And the uses as we of buildings as we go round that corner. There's Ivory Hair and Beauty. There's Pizza Go Go, and then I think you get to Brentwood Kebab just immediately next to that. Yeah.
Yes.
And just so that I understand where the parking is occurring, the concern, I assume, is that it's parking immediately adjacent to the existing tactile drop curb outside Pizza Go Go. Is that right?
Outside Ivory Hair and Beauty, I believe.
Yeah. There's a width, isn't there, where a car can park, or at least there's space for a car to park on the pavement. Now, just help me with this: is parking on that pavement in that location lawful or unlawful?
It's highway land ownership,
Yeah.
so
And so it's unlawful, isn't it? Because it's blocking a pedestrian right of way.
yes, I would believe so,
It's
yes.
a criminal offence, in fact.
I couldn't comment on the police element side of it, enforcement. Potentially, if it is blocking the footway as such, we have looked at other aspects where you have vehicles blocking the footway as such.
Is it Essex or is it Brentford that has the power to enforce against obstructions to the highway?
I don't know off the top of my head. We have a parking partnership, the South East Parking Partnership. I think it was all decriminalised a number of years ago, so it could potentially be Brentwood itself who do the actual parking enforcement as such.
So, if there are cars parking there already, which is the nature of the problem, which would cause pedestrians coming and going to the Lidl store to potentially step out into the road, that same risk exists at present for any pedestrian walking past there if the car is parked outside Ivory Hair and Beauty. Yes?
No, because the proposals detailed in front of us provide a tactile stem to the back of the footway, and it's that parking over the tactile stem which is key guidance for visually impaired road users to guide them to the signal pole as such. That's an element. The existing parking does exist there, that's acknowledged, and pedestrians may be well stepping into the carriageway itself, but there's also the tactile stem element.
I see. You don't recall the tactile paving that's already there?
For an uncontrolled crossing, yes.
You see, the solution to this issue is enforcement, isn't it?
Potentially, or engineering measures as such.
What engineering measures?
Again, it's not for us to design that. We would make a recommendation that measures be put forward to prevent the parking there. There are various tools in the toolbox that could be used potentially there. I won't get into the details of what is there from an engineering perspective because I'm not a designer as such.
You could put bollards down to prevent
You could do, yes.
passage of a vehicle onto that area of land.
Yes.
And that is something that could come forward and be addressed at the detailed design stage.
Not necessarily, because it's one of these problems that needs to be addressed now before you move on with the actual design of the signal arrangements as such. So that's why I put it in an element that needs to be addressed now, because it plays into a fact where you're going to position your signal head arrangement, your tactile paving. It's the knock-on effect element.
You can't sit there and say to this inspector that a solution to prevent parking outside of Ivory Hair and Beauty, illegal parking, could not be found consistent with a safe design of this junction. Is that right, isn't it?
Sorry, could you repeat the question?
You can't say to this inspector sitting there now that a solution to this problem cannot be found consistent with delivering a safe junction.
At this particular location,
Yeah.
it's not really for me to comment on whether there's solutions or not. It was just for us to comment that the recommendation would be made to prevent vehicular parking there.
Okay. And bollards is one way of doing it, and Mr. Bartlett suggested that in his rebuttal previously.
I believe so, yes.
Thank you. Now, next point, the New North House, you turned to that at 4.8. New North House is the building on the other side of North Road, opposite Pizza Go-Go.
Yes.
Yeah. And it has an area of sort of concrete in front of the building between it and the North Road. Yes?
Yes, correct, yes.
Is it that area, manoeuvring the vehicles from that area that you're concerned about?
It's the potential access or egress in position to the dwarf wall. I'm not sure if you can see the dwarf wall on the plans that have been provided as such. It's not shown on the detailed design drawing, which we would probably expect to be seen, but it's on A26. You can see the stop line is directly adjacent to the existing dwarf wall that resides at that property at New North House.
Yes, I see. And so the concern is that road users who are trying to exit New North House at the drop curb locations may have limited visibility of the new signal heads, and so they may choose to exit when it's unsafe to do so.
Predominantly road users who aren't reversing out, who are driving out, because the driver's side is positioned away from the actual signal head arrangement itself. So we have a near side signal arrangement. In the effect, if they can't see the secondary signal head, then there is the potential they could enter the junction when it's unsafe to do so as a result.
And so the concern is that they would enter the junction when it's on red, is that right?
Potentially, if they can't have full visibility of the signal head arrangement.
And a driver entering the junction without signal would be committing a criminal offence.
That's correct, yes.
Yeah. So, again, the issue here is one of enforcement, isn't it?
It's not enforcement because it's difficult to provide enforcement for that sort of element in terms of unless you provide a red light camera at the junction for red light running, it would be more practical to provide an engineering solution to ensure that drivers exiting or egressing New North House can see the signal head in the first arrangement, rather than falling back onto either the police for resources who are limited to do enforcement, or the only other option there would be a red light camera, and you haven't got the location to position a red light camera on that stretch potentially because of the access and the egress of New North House anyway.
So, so your evidence then is that there is no solution for this problem, is it?
I don't believe I wrote that there was no solution. I just recommended that options be investigated to look at the parking arrangement at New North House. Again, it's not for me to put forward these solutions. That's the designer's remit. It's never been the remit of the safety audit team as such.
No, you've explained it's Ms. Gore or Mr. Johnson who can come forward with the solutions to discuss. I'll see that later. Now, in terms of the issue about New York House, Mr. Bud in his rebuttal, page 23, suggests that key clear markings can be provided across the North Road approach to the signals. Is that solve the concern?
Sorry, what markings?
Key clear markings
To be positioned where, sorry?
to be provided across the North Road approach to the signals. Yes.
Directly adjacent to the stop line.
Not adjacent to the stop line.
Again, I couldn't comment on that until I would see it in a physical design as such. It's difficult to imagine where they could be positioned along there in terms of the access and the egress as such. I'd be conscious of the keep clear being so close to the existing stop line.
All right. Well, that's the first two showstoppers, as it were.
Okay.
Let's move on to the next one. You address 412. And you identify an issue arising from the drawings provided showing the north and southbound right turn stack. You identify as 3 PCU. You say this is a 414. This is a problem as in the event that the number of cars or large single vehicle are waiting to turn right into North Road or new access. The passage for any road user wanting to continue straight ahead is blocked. You get a pinch point situation where drivers become frustrated and choose to overrun the curb edges to continue their journey. This overrunning the curb which increases the risk of collision with pedestrians who may be waiting to cross these locations, and also result in curbing being damaged, which will lead to further trip-type hazards.
Can I just, once again, just make sure what you're saying here is you've got a right turn going in front of you, so you move over, you haven't got quite enough room, so you mount the curb on the left-hand side.
Yes.
That's what so I completely understand.
Yes, if we take up HG14, so we can explore this in a bit more detail.
Is that what I'm taking on?
14, yes, 14 is the outcome. Yes, it's the one we were just looking at. And on this plan, I just want to get clear what we're talking about. We've got, let's assume there's some cars waiting to turn right into the little store, and they're stacking in the lane, the right turn lane there. Your concern is that if there are a number of cars that stack back beyond where it says CP7 and go across into the crossing, the cars from behind were wanting to go through either into
Yes, that's correct, yes.
And the same problem in reverse from the other side, if there's a queue of people who are waiting to turn right onto Norwood Road, in that right turn lane, again, you're concerned, are you, about mounting the curb for vehicles particularly to go by, notwithstanding the two-lane approach?
It was, yes, from the two-lane approach as you come down into the actual target arrows, it was the backing up in the right turn of the target arrows, which would lead to a potential pinch point area near signal pole 11 as such, coming along that stretch. So the overrunning of the curb edge there as well.
Near signal pole 11. Okay, that's interesting. We've got signal pole 3 and 4 outside number 76. We're just looking at that's vicinity. Yeah.
Yes.
So the signal poles there, and the signal pole 10 and 11, they're going to prevent any significant entry onto the curb, don't they?
In terms of prevent by,
Well, to overrun the curb, you have to hit the signal.
that is a problem that might occur. It's one that we see regularly in terms of at signalised junctions, the signal heads being struck and clipped as a result of high-sided parking vehicles. I sit next to the maintenance team in my current day job, and it's a regular fault report that the signal heads are struck by high-sided vehicles without carriageway clearance or the available carriageway width to pass safely as such.
So those signal poles are going to be physical structures present the drivers will be aware of that are likely to deter the sort of behaviour you're concerned about at 415, leading to a risk of causing pedestrians. That's right. That's a physical
No,
structure.
it's not, because the physical obstruction, just because they're present, doesn't mean that they won't get struck. We've seen that from the evidence out on site from turning manoeuvres of HGVs present there. The low-sided bollards have been struck at that location on the A128, the southbound approach as such. And that's every potential for there, if it's a constrained area, for the signal heads to be struck or the curbs to be overrun as well.
Secondly, if this is a concern, it's possible to provide guardrails.
A guardrail isn't a physical restraint. It has no retaining properties in terms of keeping an errant vehicle from entering the footway as such. It's more a guidance facility for pedestrians. We would never adhere to a guardrail being put in to stop or protect larger vehicles striking a signal head as such. It wouldn't be accepted practice.
And last of all, of course, there is the extent to which the right turn lane actually has sufficient capacity. Mr. Budd turns to that in his rebuttal presentation, and he explains that your concern is based upon, he says, an incorrect assumption that staffing capacity of the right turn is insufficient for 3 PCUs. So if the officer did not have any evidence before to suggest that the right turn flow into the appeal site would be likely to cause its impact beyond the right turn pocket, either blocking the northbound ahead or resulting in vehicles mounted to the road. The authors of the limited software JST have verified the capacity of the right turn pocket is sufficient for the level of flow model. So, what is being said there? It is quite simply that the capacity, the staff capacity for the right turn are sufficient to accommodate the demand such that this sort of risk is unlikely to present itself. Now, is that something you considered in your evidence?
Sorry, could you repeat the question?
Yeah. Mr. Budd is saying that the evidence that's been produced demonstrates to meet demand such that the sort of risk of blocking back, forcing another driver onto the curb is unlikely to occur. Is that something you've considered?
We looked at the plans provided that detailed that 3 PCUs could be provided into that right turn facility. That's what the modelling detailed, but we disagreed that you could fit those 3 PCUs. That would mean bumper to bumper tight, and the difference from the modelling element is the human element. The people won't be reluctant to be pushed up bumper to bumper. We have the element of the congestion of the junction and the sort of the flows through at it. That was the query that was the concern that was raised, in that the 2 PCUs potentially would be at max at that location on that right turn into the little access, which would result in then another vehicle trying to travel north not being able to pass around the rear of the vehicles. We think it was very unlikely that you could actually get 3 PCUs in there to turn right.
Right, sorry. 413 of your proof. 413, you identified safety orders withdrawn and provided. It was evident that north and southbound right turn facilities have limited stacking space, 3 PCUs maximum.
Yes, correct.
You've identified the stacking space as 3 PCUs max.
No, I've stated what was put in front of us, that it was stated that they felt that 3 PCUs could be done. Whether I agreed with that was a matter of concern, and that's shown on A27 in the proofs. That 2 PCUs are shown positioned there, as they probably would be, not bumper to bumper. A third PCU would then back up into the swept path of any larger vehicle attempting to travel north along that stretch. It's the human element that has to be taken into consideration.
Right, okay. Well, I'm not going to be able to resolve 2 PCUs or 3 PCUs, if I will say what you used to say on that issue. Right, let's move on then from looking at that issue. The next point you raise is at 418 in the proof, and that refers to an issue of articulated HGVs entering and exiting the new access and colliding with stationary road users waiting to turn right. You explain at 490 that the swept path drawing shows that when turning left out of the new access, these vehicles have to considerably encroach into the right turn facility and overrun the edge of the northbound stop line. So any station users who may not have the opportunity to turn right will be vulnerable and at risk of being struck by HGVs, and any road user who is stationed at the stop line will also at risk of being struck by turning HGV. So this is HGVs servicing the little stall, turning into the store, the site accesses. That's the first point you need to address. And I think you raised the same point about exiting here.
Yes, it's left turns out to head southbound along the A128, and then it's the left turn in that encroaches into the right turn lane of North Road as well.
Right. And
Sorry, say that again.
So you've got the HGVs turning left out of the little access to travel southbound, and then the other one, which is shown on A27, it's the bottom left picture. As a southbound HGV enters the site, they have to transverse the right turn pocket for North Road in order to be able to make the left turn movement into the site. So if you've got any queuing road users waiting in that right turn pocket to turn right into North Road, an HGV won't be able to pass them, or it would have to potentially mount the curb, or you'd have a nose to tail collision as a result.
okay. So we've got an HGV. Let's take the example of an HGV going into the site first. If the problem arises when at precisely the same time there's a queue of cars waiting to turn right into North Road, yes.
The problem would be exacerbated by road users turning right into North Road if that's on the same stage, which I believe it is, although we hadn't seen the staging diagram.
So the HGV waiting to turn right, with that in place, it's likely to hold the traffic behind it, isn't it?
Sorry, could you repeat the question?
Yeah, with an HGV waiting to turn right into the site, it's likely to hold traffic behind it.
If the traffic is heavily congested at the time, it may well hold it, or the human nature element of it, it might be that they continue on their journey forward as such.
Your concern, as I understand it, is about congested periods, yes?
Or any period where there could be road users waiting to turn right into North Road.
So, an HGV waiting to turn right, you've already explained issues about what potentially happens to vehicles that way. As it approaches, it can see vehicles wanting to turn right into North Road, and an experienced HGV driver will know just quite how far the line around is that they're going to need to take vehicles to that side. And we can see from the routing just what that means. An HGV going to do that turn is going to stop. It will block the traffic behind it, and then those turning right into North Road can pass into North Road perfectly safely.
I can't comment for HGV drivers as such with the experience or the ability that they have as such. I can only comment on past evidence that we've seen of overrunning of curbs, of nose-to-tail collisions, of damage to signal pole arrangements. We just would be looking that there is the potential for the overlap of a running lane as such. This is why we have cyclist collisions on the near side of HGVs as such and the various parts, but I can't comment on the ability of an HGV driver to be able to sufficiently make that movement to that intricacy each time.
Let's look at the other situation, which is an HGV leaving the site, and your concern is about it turning left, is that right?
Yes, egressing the site to make a southbound manoeuvre towards Wilson's Corner.
And the concern is that there may be cars in the right turn pocket waiting to turn right into the site, the site itself, that would be at risk, is that right?
Waiting to turn right into the site and waiting at the stop line itself. So depending on the level of flows, if the junction hasn't had the ability to clear the right turn into Liddell, that was one of the problems. And then the second detail that I picked up was the fact of road users positioning themselves at that stop line. In heavily congested times, road users like to inch above a tiny bit over a stop line as they creep forward, which would then put them at risk of having their front offside part of their vehicle struck by any HGV making that left turn manoeuvre out of the access. And the A27 shows that there's an overlap of the top right part of the stop line.
So let's just think about the way the signalling works, as proposed by Mr. Budd. Mr. Budd has North Road and the site access, both running on the same stage. But Ongar Road is on different stage, yes?
Yes.
So if I'm driving my car to turn right into Liverpool from the south, so I've got North Road on my left, I go through a green, whilst North Road and the site access are on red. between Ongar Road going green to the North Road and the site access lights going green. And that's the point when I can drive into the site access, clearing the right turn lane, and then giving space to the driver to turn his HGV left into Ongar Road when his light goes green. That into green period provides the ability to clear the box, doesn't it?
No, if the area is already subjective to southbound congestion, the intergreen will run, and you could already have road users waiting across the junction itself
I
to
see.
clear.
So I can't turn right because there's traffic blocking back on the southbound lane of Ongar Road across the junction. That's the situation you're worried about.
Predominantly, in terms of heavily congested times, that was the issue.
If that's the case, then my HGV can't turn left anyway because the road's congested in front of it. Yeah.
Potentially.
Yeah. You see, if I'm blocked from turning right into the site, the HGV is also blocked from turning left out of the site. Yes.
It depends on where they've positioned themselves on the southbound approach in terms of queuing as such. So a queuing southbound road user could have left the stop line and just positioned them past the actual central refuge, still allowing that turning manoeuvement of the HGV, or they could have well queued back in front of the actual HGV swept paths. Again, it's subjective to the road users at the time and the conditions and the level of congestion and the human element of it. Some will push forward and be aggressive in their stance across the junction in heavily congested times. Some people would adhere to it and sit and wait back at the junction itself.
And just going back to the intergreen period, Mr. Budd in his rebuttal brief at page 24 identifies that if there were issues here, the intergreen period could be extended through the use of VA to ensure sufficient clearance time before the next stage receives green. That's possible to do, isn't it?
I don't know, I'm not a signals expert as such.
And in terms of intervisibility, the right turn pocket from a vehicle sitting at the side stop line waiting to turn left, there is a very clear intervisibility at that location.
Sorry, could you explain the intervisibility query?
So if I'm at the stop line of the little store in my HGV, high up in the air as they are, waiting to turn left, I've got a very clear view of the vehicles in the right turn pocket. There are a few metres in front of me.
Of the right turn pocket, yes, but not of the A128 southbound.
Thank you. That's what I needed to do on that problem. The next one. Oh, sorry, there's one more point. Were you aware when you wrote your road safety, or wrote your proof that there would be 2 HGV movements of this sort a day into and out of the store?
I believe it was detailed in the transport assessment about the HGV movements. It's in terms of the level and severity, it's irrelevant of the actual number of movements. If we feel there's a problem between there being 1 movement, 15 movements, 20 movements, we're still duty bound to raise it as a safety related problem. The number of movements is irrelevant. If it causes a problem with 1 singular movement, then it gets raised as a problem as such.
So when you're addressing your concerns about safety, when we think about risk, we often think about the magnitude of consequences of something happening and the frequency at which it might occur. In your assessment, county?
We,
Which seemed positive.
as part of the safety audit process, and we've had detailed discussions with this, we don't quantify risk in terms of safety audit problems. It's, again, there's a number of influencing factors which can affect risk when you're looking at problems as such, and it's very, very difficult to ever quantify risk when you're writing safety-related problems as such, which is why it's not done.
So the issues that you identify in your group are not matters, the risk of which you've assessed.
The safety audit process isn't a risk assessment process.
Now, lost my place, sorry. Give me a second. Which, yeah, I think the next issue, you turn to 426, and this is a concern relating to protection for offsite conditions for road use. And this is when who's exiting the new access road and North Road. It's offsite conditions, so you're concerned about somebody driving out of North Road, turning right into North Road, colliding with somebody driving out of the side access and turning right into Argyle Road. Is that right?
Or going straight ahead, performing a straight ahead or a turn left movement out of the little access. So it's, in essence, it would be road users exiting North Road, and rather than yielding, they would attempt to turn right in front of the path of road users going straight across from the little access into North Road, or turning left as such.
I see. Now, and I think it's that concern that has led Essex County Council to conclude that North Road and the side access should have separate signal stages. Is that right?
I couldn't comment on the County Council's decision as such. It was, we placed it in as a safety audit problem.
Well, it's just that at 4:30 of your group, you say we therefore recommend you sideline approaches run under the phase, so you have.
We've commented, but the decision would have lied with the overseeing organisation as such.
I see. So, in terms of crossroad junctions, there are very many crossroad junctions in this country, aren't there, that run on two phases.
Two phases in terms of
So
a north and south and an east and west.
Yeah.
That's correct, yes, there are across the country.
Yeah. It is something that drivers are entirely familiar with these days. Yes?
I wouldn't know, I haven't driven across the whole of the country as such. It might be that some drivers might be aware of some might. It's subjective. A new driver might not be aware.
Right. In terms of a three-stage junction, that too is something that people are entirely familiar with.
3 stages in terms of
In terms of a north-south on a single phase and then an east and west on two separate phases. The signal control junction.
okay.
That's something we encounter when we drive around, isn't it?
I believe so, yes.
Yeah. And so there is nothing unique, is there, about the proposed staging of the junction, the nature of this junction.
The, the uniqueness is its location. It's, we take every single traffic signal junction across the country will be in a unique location with unique traffic flows, unique pedestrian movements, unique vehicular movements as such. So although they might encounter similar junctions, they're not encountering unique movements across the junction itself and the unique interactions. They're all different as such.
And so, what is it about this particular junction that means that if drivers drive inbound North Road and out of the little access at the same time, they will drive into each other?
In terms of gap acceptance, I think we detailed that if there is a low gap acceptance, it's the opportunity for road users to be able to join the right turn into Ongar Road itself. When you have the alignment as such, which you do have on the approach, you have a road user exiting little access to turn right up to the A128, and on A20, A30 actually, you can see the positioning of where you're positioned, because there is no target markings for road users turning right out of North Road. It'll be difficult for someone to figure out where to position themselves to be able to turn right into those roads. And as a result, and we do see this across junctions in Essex, the road user has a green from North Road and feels they have carte blanche to turn right across the path of the road user going straight across. And that is evidence proven. I've put in 4 casualty reduction sites in the last 5 years as a result of that, in terms of road users turning right across the path of the other road users travelling straight across.
I see. Many crossroad junctions have no markings at all, don't they? And they function without any issue.
I couldn't comment on whether they function without any issue. I did some due diligence and looked at 2 locations in proximity to the appeal site itself, Middleton Hall Lane at the A128, directly outside where we are today, and the A128 High Street or Weald Street. Last 5 years collision data, both have right turning road users turning across the path of road users going straight ahead as such. So it's that confusion in the heavily congested times, and there's limited gap acceptance as such, and people are taking that opportunity to turn right. So it's proven, basically.
Sorry, whereabouts do you refer to those junctions in your evidence?
It's not detailed in the evidence. That was just some additional work that I did in background.
I see. Well, I can't ask
Okay,
questions about junctions I don't know
No.
about that aren't referred into evidence, which I've taken no instructions on. In terms of North Road, it's a 20-mile-an-hour zone, isn't it?
I believe so, yes.
And the middle access will be limited to 10 miles an hour, won't it?
I believe so. I haven't seen the signing and lining drawing which shows anything to detail that it's going to be 10 miles an hour.
So the approach speeds between vehicles are going to be low, aren't they?
Potentially.
And we also know, don't we, that the authors of the Lindsay's of looking at the staging of this junctions confirmed that the staging adopted was appropriate. It didn't require full stage.
I couldn't comment on the Lindsay element of it as such.
Okay. Mr. Bunn has a drawing in his rebuttal that he provided to Mr. Johnson on the 3rd of December 2021. Can I just take you to that?
Which, I'll have to look at this electronically. Which one is it?
It's Appendix JR2 to the rebuttal.
Okay.
Sorry, it was.
It's P3.20.
Is that the cover page? Okay.
Right, that's got that. That's that, isn't it? Okay, so we just keep on going. Where's the actual appendix?
I'm looking for appendix, appendix JRB2.
JRB2.
Thank you. Yeah, so we've got an email, and then if we turn on through the email, you'll get to the drawing.
Just got small one.
So it's a drawing that's headed site access proposals with improved footways and swept path for maps legal artists northbound and southbound. SCP 18254 ATRS K800/05.
800.05.
Yeah.
Yeah, that's the one that's on its side. Yeah, I've got that.
And on 05 we can see the artics going through the junction. That's what path. And we've got a similar.
Sorry, which is the sweat path for the Arctics?
It's the green line.
Okay.
And then if we turn to the next drawing, we've got 06. And here we can see the alignment of vehicles exiting from both side roads. And we can see the sort of amount of space within the centre of the junction for a right turn to wait whilst ahead or left turning vehicles clear. There is more than sufficient space there.
There is sufficient space to make that right turn manoeuvre.
Could I ask for a copy of each of those at some stage? Sure. Again, bigger scale. Sorry to be so.
It's A3 is best you can do.
That's all A3 is fine, but I just hate it as well. Especially when it's on its side.
There is something about drawing to electronic that I just can't experience in 100, but
I put it at my age, but I
no, I don't think it's mine too. So it is, in terms of the assumption that the driver receiving the green signal will automatically assume they've got priority over traffic exiting from the axis opposite. Just explain to me what it is about this junction that means that drivers will assume compared to other junctions where opposite limbs of a junction both trigger at the same time. What is about this one?
Sorry, could you repeat the question?
Yeah. What is it about this junction that means that drivers receiving a green signal will assume that they have priority over traffic exiting the axis opposite?
I think it's one, the variation in the side road movements that we've seen, and two, when you come across from North Road in terms of the alignment as such. I'm looking at the drawing.
Yeah.
It's that opportunity. It's them sitting in the middle, waiting to turn right across the path. You've got road users waiting to turn right to head A128 northbound. It's that gap acceptance element It's whether they've got an opportunity to actually make that right turn. They have to make that split decision, especially in heavily congested times as such, to move across, basically.
Yes, but that's no different from any other junction where
I wasn't talking about any other junction. My safety audit is solely related to this junction and the circumstances and the conditions that we've been presented.
What is it specific about this junction? That's my point. Your point could be made of any junction where you emerge at the same time as someone coming in. What is it about this junction?
I think it's the congestion and the gap acceptance during heavily congested periods, and that opportunity for road users to be able to turn right along the A128 southbound as such.
Okay. So we're talking about somebody, let's take somebody turning right out of North Road. Ongar Road is heavily congested. Was it both directions, is that the concern?
More so southbound.
Right. So the driver from North Road is in the middle of the junction. They move forward even though Ongar Road is congested, and even though the junction is blocked. Is that right?
They would move forward. I can't comment on the actual situations. They're going to vary.
You're identifying the problem. I'm trying to understand what the problem is that you're describing.
It's the gap acceptance. So road users waiting to turn right have to anticipate a road user turning right across their path to head northbound. They have to anticipate a road user going straight across to North Road, and they also have to anticipate the left turn manoeuvre for them being able to wait there in the middle and then find a gap in the traffic to be able to turn right. It's that gap acceptance issue.
I see. And that gap acceptance issue is no different from any other junction with two opposite flows being allowed in a congested area anywhere in the UK.
Again, I can't comment on any other junction. As I said, it's site-specific circumstances.
Is Essex County Council currently engaged in identifying junctions where traffic is signalised on the basis of the same phase opposite one another and changing all those junctions to four-phase junctions?
I don't know what the ITS remit is. Unfortunately, I'm not an ITS engineer.
I'll ask that at the school later and see whether this is just an issue with this junction or whether this is being pursued elsewhere. Thank you very much indeed. Where are we in terms of time?
I'm just saying, thank you, Mr. Taylor. Mr. Upton? Sorry, have you finished? You haven't? Ah, sorry. You said thank you, and I thought, oh, eager anticipation on my part. How long ago?
I think I've got another sort of 20 minutes.
Well, I'm happy. And then how long for re-examination?
A few points to come up with, might take just a bit left, I don't think it's probably 10 minutes.
So we finish at 1:30, is that? Are you happy with that?
Yeah.
Be nice, clean and neat.
Yeah,
Yeah, let's horse on, yeah. No, let's horse on. I'm not starving yet, you're all right. And then the more we do before I expire, the better. So.
okay, so that is that one. I think the final problem, number 2, is in this section, is at 432. And that's the issue about notice to have conditions in stationary buses north of the junction. So
potentially I haven't observed the current bus situation out there in terms of backing up. I'm aware from the details provided that there can be issues with northbound road users being held up from the existing bus arrangement.
Are there any recorded accidents as a result of the bus stop and the bus forcing traffic around?
Don't believe there's, not in the last 5 years, it hasn't been picked up in the collision details.
And just so that I understand, what is it that the scheme does to exacerbate the risk associated with this? Or is that something you've not considered because you've not looked at risk?
We would look at the safety-related problem as a result of the bus being positioned there and the northbound movements and the traffic island as such and the potential for the overrunning. But we will examine the scheme as put in front of us.
Okay. So in terms of my question, then, what is about the scheme that exacerbates the existing problem?
I think you have a left turn out of Liddell which overlaps the bus lane and it runs close to the centre island itself. And then you're introducing a right turn manoeuvre along the southbound approach as well. So rather than a single lane approach, it's a 2 lanes approach.
Have you got the statement on the ground?
No, I haven't. What's the document reference?
There might be, there should be one there somewhere.
That one. Okay, it's that.
Page 13.
Which point, sorry?
Sorry, apologies. Paragraph.
Paragraph 640, page 13, in C 3.1.
So is it whilst the access itself remains an area of disagreement?
That's it, exactly, yeah. At 641, it's agreed that the route to be taken by Routes drivers be via Ongo Road South, that this can be controlled by an active working condition via the delivery service and waste management routing plan. So the vehicles are not going to be turning, well, the HGVs are not going to be turning right out of the front access, are they?
I couldn't comment on Lidl accesses vehicles as such. We have to look at it as a pragmatic point of view that there might be an opportunity if there are issues on the A128, if the A12 is shut, and in the event that a right turn manoeuvre needs to be undertaken, then we pick it up as a problem. We can't say just because Lidl drivers aren't scheduled to do it that there won't be actual HGV drivers or certain drivers who might make that right turn manoeuvre.
I see. So we've got to design our roads, consider safety on the basis of assuming that there will be a breach of a planning condition.
I couldn't comment on if it's a breach of a planning condition, but we would expect the roads to be able to design to facilitate the movements of all types of vehicles throughout the junction itself.
Okay. Thank you. Now, just help me with this. That's all the problems that you said in section 4 need to be addressed that the current design states are really explored. And
Sorry, could you repeat the question?
Yeah. None of those issues demonstrate that there would be any unacceptable risk in terms of impact on highway safety as a result of loss of coverage.
No, I have to disagree, hence the reason why I put the problems in my audit. I still feel there is an acceptable risk to highway safety.
That wasn't the answer I was expecting, Sense, because you told me you didn't raise risk. Remember?
You've asked me whether I've risk assessed it,
I asked you whether you considered risk. Yeah.
but not as part of the RSA report.
And you said in your evidence that none of those points that you raised that come out of the RSA report were based on an appraisal of risk.
They're not.
Does your evidence contain any appraisal of risk?
It would retain a subjective look at whether there is a safety-related problem.
Whereabouts in your proof do I see the appraisal of risk that looks at frequency of events and magnitude of consequence? Why do I see that?
I don't believe that's in my proof of evidence.
Because you adopted the approach, which you're entirely qualified to do, of undertaking a road safety review, which doesn't look at risk, as you've explained. That's right, isn't it?
That's correct, yes. The road safety audit isn't a risk assessment process, as I've detailed before.
And so the conclusions of your proof are not conclusions that go to whether or not there are acceptable or unacceptable risks associated with the scheme.
I don't believe my proof has commented on the risk element of it as such.
Okay. Now, just turning on your proof, you've got a section 5, problems raised as parts of the GHB consultant RSA, and you've got outstanding problems there.
Which page, which number are we at?
This is from 5.6 onwards,
Okay.
and I think that all of the issues that you've raised there are matters that we've already addressed.
I've not having gone through each one directly or to tick them off.
Those, I think the same is true in section 6.
6. Are you referring to the Taylor Bowie stage 1 safety audit or the stage 2? I don't believe that Taylor Bowie safety audit stage 2 raised any problems in relation to the design proposals.
And you've looked at the drawings and you have identified some issues and set 2 through to set 5. What I don't get from this is whether the points that you've raised at 7.2, 7.5 are in your category of outstanding problems which should be addressed at the detailed design stage.
These have been supplementary comments that I was asked to provide upon review of the Taylor Bowie detailed design stage as such. When I was asked to review the Taylor Bowie stage 2 detailed design, I'd already written my RSA reference 8732.
Yes, but that's not answering my question. It's a respect. Are the points raised in 7.2 through to 7.5 outstanding points that can be addressed at the detailed design stage?
Detailed design, yes.
The next one is whether the qualified carried clearance rate provided forwards in the poles. Is that detailed design?
Potentially, you would hope that would be agreed at planning because that's elements of footway and land take that might be required. So you would hope that that would be bottomed out before you get to detailed design.
Okay. Say there are no consent form, no details of proposed design, no expectations to keep that bollards or refuge islands.
Yeah, that would be detailed design.
That's all detailed design, is it? All the points consent form.
Road markings. Depending on the road user adopting the correct lane or the incorrect lane on the approach as such, you would hope that that's would be resolved before you got to detailed design.
So just explain the risk there. That's related to A1 to X alpha.
As I detailed before, it's not about explaining risk, it's about explaining the safety related problem.
Yeah. Okay. I'm just trying to understand what the problem is, that somebody might just get in the wrong lane.
It's providing advance notice to road users on the correct lane discipline through the junction as such. If you don't provide the correct prior information, you then get late lane change manoeuvres, side swipe manoeuvres, general confusion throughout the junction.
That's a combination of signage and road markings to tell people to get to the right lane.
Potentially, or depends if you need any additional land take on the approach, on the southbound approach.
What would you need the additional land take for?
I don't know in terms of lane discipline.
Fine. So we'll put that issue in the potentially needs addressing. I'm forget about the comment on that point is evidence chief. Traffic signal design. There's an issue about a lamp on pole 4 being positioned in tactile pavement. Is that right?
Are you asking me, is that a detailed design
Yeah.
issue? Potentially, yes. You would hope that that would be ironed out, the detailed design.
I see. So, just so I clarify, the drawings submitted for stage 2 to take power, the only comments that would be possible are the ones in 7.2 to 7.5, yes?
From a personal perspective, having not safety audited it or looked at the drawings,
Okay. But to that extent, those drawings address the issues that you and I discussed by your section 4. You don't repeat those issues in relation to these drawings.
that's why I wrote further safety-related problems raised as part of the review of the drawing. So these were in addition to the original drawing problems that I picked up. So they're in addition, and that's stated in 7.0.
Okay.
Okay, thank you.
Thank you, Mr. Taylor. Mr. Upton.
I've got 10. We'll try and do the boxing cocks. As Henderson said, I really just want to pick up a couple of the details that you were being referred to. But can I start with the general question? It arose earlier about your categorisation, about things being outstanding problems that you call showstoppers that need answering now, and ones which might be answered at the detailed design stage. Are you able to help a bit further as to what falls into what sort of category? I mean, I think it was being suggested to you, for instance, that the issue of bollards and what might happen at number 76 was really detailed design. Why is it fallen on a particular side of the line?
It's because it would affect the potential position of the signal arrangement, the tactile paving, and there's obviously going to be some curb build-out works as well. So everything that you'd expect at a stage one with carriageway and pavement works to be resolved at that stage as such, which is why we felt it was a pertinent issue to pick up early on as such in terms of stopping vehicles to potentially park across that, because it might affect the tactile paving and open up a series of other issues as well. So.
And you gave a couple of references to drawings. Now, I'm conscious there's a bundle A around the drawings, but sometimes there's more than one image on a particular sheet, so it might be helpful to identify which is the part of the drawing that helps address particular
Okay.
things. I noted A26 as a drawing which addresses the point when you had a discussion about the North House.
Yes.
And I think you've got, you may have actually be doing this out of plan, but in bundle A, 26 appears to come on page,
Yeah, 994. 994.
this is very helpful. We also have a hard copy, but you will be asked about things like the new board, the global board, and how people might be reversing out of New North House, and the stop line that's now been indicated. Could you, perhaps by holding it up by description, just show what is the relationship of the vehicle at New North House and this new stop line that you're concerned about? Where are we talking about?
So, just to the north of the stop line, you can see the dwarf wall arrangement.
Stop right there. Stop line to which?
So North Road stop line,
Yeah, got you.
dwarf wall there.
Yeah.
There's an access and egress drop curb just there,
Yeah.
as such.
Right.
And it was vehicles accessing or egressing that drop curb in proximity to the stop curb, to the stop line, in terms of visibility of the signal head, the primary signal head or the potential secondary signal head right on the offside and in the little access.
It was suggested that we sort of keep clear, but you said it's difficult to imagine that it being so close. What we were referring to then?
Again, I'm not an ITS designer, but I don't think I've seen a keep clear marking in direct proximity to a stop line. Keep clears are normally positioned back. The stop lines are there. Obviously, it's a reservoir, it's a capacity for storing vehicles as such. If you had to keep clear there right at the stop line.
Can we just define what we mean by keep clear?
It's just picking up what I think Mr. Butler identified as a potential solution.
What do we mean by a keep clear marking?
What do you understand by it?
Just the physical keep clear. So it's a singular line with the words keep clear and a line underneath it. So
We're not talking diamond, whatever.
no, not yellow box. No,
Just
no.
wanted to check.
And again, it's the compliance with keep clear if you, in queuing areas in close proximity to a stop line, whether people would actually adhere to it or not as well.
And since we've got this drawing, because we can now unfortunately see numbers 72, 76, and 72 is the hairdressers, or 72, 74, and 72 is in the corner. We can see that relationship that you've been discussing. But again, I suppose the question would come up, why can't one imagine where the bollards might go at this stage? There's an issue that we can answer that.
It's more the knock-on implications in terms of preventing vehicles parking across that tactile paving, because this is your fundamental design in front of you, your signal arrangement, your pole arrangement, and if people are going to continually park across the tactile paving as such, it's an issue that would have to be addressed now rather than later at the detailed design stage.
Another reference that you gave us was with regard to the stacking capacity as a demonstrate what could be bumped up and what people might do. You referred to A27 as a drawing,
Yes.
which I think that's I don't think it's also magically produced, but within the
There's a magician over here.
there you go. This sounds very promising.
If not, it's the next picture down in the on the PDF.
This has essentially 5 images on it. But when you were referring to the spot about the capacity of the right turn, which bit were you wanting to draw attention to?
It's the drawing on the far right, so you can see 2 PCUs stored there currently, and we've been detailed that you could fit 3 in there as such, but the human nature element of it, if I'm going to be rubbing a bumper to bumper, you could fit 3, or I'd be entering the taper markings. 2 fit relatively comfortably. That's a Jaguar S-type, 2 Jaguar S-types they've done on the swept path analysis, but 3 would enter your northbound manoeuvre, as you can see on that far right drawing.
Just the distance from it, there was, when you've been talking about the Wates Way facility, this was also a drawing which assists us on that, is that the reference?
Yes, it's the top left picture for the left turns out of Lidl. So that is the encroachment of the existing right turn facility, and then as you look, you can see it crosses over the actual stop line. So the same drawing, top left of the picture, an HGV turning left out of Lidl, obviously the encroachment into the right turn pocket, but just as importantly, the overrunning of the stop line, the top edge of the stop line. And that details that an HGV driver makes that manoeuvre perfectly every time from the tightness of the radii provided.
This hasn't got the swept back on the left, does it?
That's the top left picture.
Oh, sorry. Thank you. Right. Okay, yeah.
So you can see the overlap of the stop line, and then obviously the encroachment into the right turn pocket to turn right into Lidl as well. Yes, that is the bottom left picture on the same drawing. So as an HGV comes south, in order to make that left turn manoeuvre, it requires encroachment into the right turn lane for North Road. It turns left in.
One other one that we were being asked about, we did get drawing whilst we were hearing from you, was this point about the relationship of site access and the off road. And we were taken
I haven't found it yet. Sorry, it's in bundle E, is it?
So your search on it is E in it, hopefully page
537.
yes, so page number 537, that's on the page.
Yeah, we've given up.
Are we? Okay. Right.
Almost there.
Let's skip. Hang on. So I've got a hard copy of this one.
Hopefully, one that has some green lines on it for the steering one for the vehicle.
Bear with me. .537, yeah, got it. Okay. Yeah, it's the diagonal one, wasn't it? Upside. Yeah.
So you remember what we asked about, problem relating to the cars coming from, or vehicles coming from different directions, more road and little access, and about how that might compare to other junctions. In terms of how people, this obviously junction, but approach the junction, if you were going straight ahead from North Road, is there anything about that that you find unusual?
Yeah, the current alignment, if you draw a straight line from North Road, it diverts road users straight into the offside lane to the exit of Liddell, so there's quite a deviation in route itself. So the natural movement for anyone exiting North Road would be head on with a right turner coming out of the Liddell access. They have to sort of kink and they go around the central refuge to pick up their lane itself. So you can see that on the, it's shown on the swept path of that one. It's actually, the car actually has to move quite a way to the left and straight ahead to deviate around the island itself. And that would be anticipating the subsequent right turn out of Liddell as well. So that's quite a significant deviation in terms of alignment for that straight across manoeuvre.
Okay, then obviously you answered another question that you to go back to that. I think that's all I need to ask you for explanation.
Okay, thank you. I've just got one point for clarity, really. If we look at 801, the one with the A27,
Yeah.
The right hand, the big one on the right hand. If you're going north on Ongar Road,
Yes.
you were talking about cars backing up, going right turners, stopping. There appears to be, well, the red areas, there's quite an area to the left of that carriageway to the left, which you'd have thought you could have squeezed round. Maybe not ideal, but
To pass around the rear.
yeah.
It depends where road users position themselves to turn right. I suspect that if you have a third vehicle in there, then I don't know whether there would be the capacity to get anyone past.
Okay. All right. I don't think I've got anything else. Thank you for your time. It is now just about 20 minutes. 2 o'clock or 2:50. Everybody go and get lunch. Have you got it in?
Day one, I'm not sure.
2:15. 2:15. People still have a time for the rest of the evening. Right. Okay. Thank you. Adjourn until Any procedural matters anybody's got? No? No, right, okay, Mr Upton.
I was going to call Mrs Hilary Gore. In terms of documents at this stage, it's clearly proof of evidence and a summary, and I was going to start with a summary, and there may be a couple of points to add as we go through that, but perhaps also worth having to add Mr Budd's rebuttal, because obviously some direct points there would be worth picking up and trying to clarify. In anticipation of that, can I give you a document that will come up during that, which is, well, I can show it to you, and then you can see why I'm trying to save time using it. There's been a dispute about which scenario one uses in terms of travel time and the effect. And Mr Budd usefully has a table 7.2, but one thing he left out was a column that we rely on, he doesn't. And you'll see here in the columns, and it's the one handle, table 8, Stantec PM journey time comparison, and Stantec sensitivity single. That was a series of numbers that Mr Budd says that you shouldn't rely on, and Mrs Gore does rely on. So the idea of putting this in here was that you'd have essentially what are 5 scenarios now, and you can see the different numbers, and hopefully then we're not arguing about the maths, and it's all on one sheet. But we'll come back to that when it comes up, because it's obviously about potential additional journey time. I was able to give them a copy just for lunch, and it's obviously for them to check, but it is just meant to be the amalgamation of 2 different sources in one place. Mrs Gore, can I turn to your summary, but equally use it to introduce you to the inquiry, and hopefully you've got all your documents you need. Your particular role is the Strategic Development Manager, bracket South, I presume there's a North as well, for Essex County Council, which is the highway authority for this area. And as you say, you've had some 38 years experience working in highways and transportation for both public and private sectors, and you set out your qualifications there as well, including being a member of the Chartered Institute of Highway and Transportation. As you note, it's your colleague Brendan Johnson who was dealing with it as the case officer, and you've taken it over really at the appeal stage, but you do explain that you've been familiar with it for much longer overall. And I think, unless there's anything else, I think in terms of introduction, I was going to ask you to turn to your section 2, because obviously the history has been relevant as well of your summary. And perhaps you could read from 2.1.
Thank you. The plan application 20-01221/4 was submitted in August 2020. The site access details were amended in November 2021 prior to the application being determined. The amended plans, which were submitted in November 2021, included SCP drawings SK 800 Vision A, ATR SK 800 01-04, and location surveys GPR plan, which are core documents A26 to A31, which are the subject of this appeal. ECC has previously raised concern about the proposed signal junction both during the pre-application discussions and for the 2019 application, which was withdrawn. In summer 2021, an independent mediation process was undertaken to try to resolve the highway concerns. This included VISIM modelling of the wider highway network, including Wilson's Corner. The application was refused in December 2021 for 4 reasons, details of which are included in my statement of evidence. My evidence deals with all 4 reasons for refusal. The appellant sent detailed design information to ECC in May 2022, details of which are included in paragraph 2.8 of my statement. ECC was unable to assess this at the time due to resourcing issues.
I'll just pause there. 2 things. The further information you mentioned coming in May 2002, that's something that Henderson's now addressed. Is that the relevant documents, or will there be further?
The original RSA wasn't based on those, but he has looked at them subsequently, yes.
And the second one is that there was a serious question about what happened in November leading to the December 2021 refusal. Could you just explain from your perspective considering how it came about in November?
In respect of the RSA, sorry?
Yes.
Yes, in respect of the RSA, we commissioned the road safety team to do a road safety audit for us in the middle of September. It's about the 14th of September. That was turned around fairly quickly, as Mr Henderson has pointed out, and we received it back on, I think it was the 25th of November. We then had some discussions with Mr Henderson about just to outline a few queries and just discuss it. We then subsequently wrote our recommendation to Brentwood Borough Council on about the 10th of December, and the planning committee was 15th, I think, of December, so shortly afterwards.
It's probably also a good point just to pick up the relationship between your evidence and Mr Henderson's evidence. If you get a road safety audit like that, how does that feed into what the County Council does when it's responding as the statutory constitution? To what extent is it the answer, or how much further do you have to assess things?
It forms part and parcel of the assessment. Obviously, we do take road safety considerations very seriously, because we're the Highway Authority. We've got a duty to make sure that any improvements are safe on the highway. It's considered in the round with all the other aspects that relate to that planning application. But it's an internal document that's used to advise us as part of our decision-making process.
You briefly deal with the relevant policies. I think you need to rehearse the relevant parts of the development plan. But you then move to talk about standards, and perhaps it is just worth picking that up. Firstly, perhaps you could read your 3.3 and then supplement it.
Yeah. ECC uses Design Manual for Roads and Bridges, DMRB, in addition to ECC guidance to assess highway proposals. Manual for Streets does not include specific geometric design guidance for junction layouts, such as traffic signals and roundabouts.
There's been some criticism made of your reliance on Design Manual for Roads and Bridges, as it's, strictly speaking, written for, I suppose, the national highways, with that in broad terms. Could you, I know it's covered in your evidence as well, but just to summarise why it still remains the relevant document.
Because it does provide the detailed guidance. There are other documents like Manual for Streets in Chapter 6 which do provide more general guidance, but that is the one that provides the technical details. Manual for Streets was really designed for residential roads and for streets, and there is reference in there to say that the more detailed guidance is DMRB in certain instances. And there's I'm just trying to think of the name of it. It's the Eastern Regional Development Management Forum that provided a guidance note on where we should use Manual for Streets and where we should use DMRB, and that's included in Mr Budd's evidence. And that specifically says that we should be using DMRB for roads that their function is specifically movement, and streets are more for where the function is placed.
The site and surrounding area, obviously, have a chance to familiarise themselves with it. You described the role of Ongar Road in particular, and also Wilson's Corner. Now, one of the comments made is that there don't appear to be any proposals for Wilson's Corner, despite that double winning roundabouts high level of use. What is the current status in terms of any proposals or studies?
Wilson's Corner was looked at in quite some detail as part of the local plan evidence, including the VISIM model that was then used for updated for this appeal. And It was identified that there were issues, that there were existing issues at Wilson's Corner, but they'd be significantly exacerbated by the local plan traffic, and that mitigation was needed, but no specific schemes have been identified. And it has been identified that there will need to be a task force set up to look at the various alternatives. I think in the local plan they looked at 3 options, but none of them came up with the necessary mitigation. So it's agreed that a task force should be set up between the Borough Council and the County Council to decide what measures would be appropriate for Wilson's Corner.
This may be something I've said, but there seems to be dispute about the interaction between Wilson's Corner and what the new access would be. Sort of, broadly likely that the new access is further away from Wilson's Corner than would have a direct effect. Why are you concerned about that relationship?
Because traffic regularly queues back from Wilson's Corner right through the site access junction, and it regularly queues back virtually to the A12 overbridge on Ongar Road, and it's a problem not only during the peak hours but off peak as well. Throughout the day there's a lot of congestion right through the proposed site access junction past the appeal site.
It's probably appropriate time for me to ask about the peak periods. Obviously, it's something that one always talks about when we're looking at traffic impact. In this instance, how does the weekday peaks or Saturday peak relate to what's happening at other times?
As I said earlier, that the network is congested throughout the whole day. We've found that the traffic flows tend to be lower in the traditional peak because of the inability of the network to cope. So the actual throughput decreases, which is reflected by the queues. And then as the traffic clears, the congestion clears, the traffic flows increase.
This is where the suppressed demand question comes in.
Yes, that's right.
Thank you. Those general points. Then we move to your chapter 5 in your summary is about the impact on the highway network. This is a wider picture. Could you read your 5.1?
ECC believes that the introduction of a signal junction for access to the appeal site will result in a severe impact on the highway network surrounding the appeal site. The impact on the network has been raised as a concern since the first pre-application discussions in 2014. The VISIM model that was undertaken by Stantec for the mediation included input data provided by the appellant, including access details and proposed development trips with 30% pass-by and 70% new trips. The Stantec mediation VISIM modelling tested several scenarios. The reference case, which was base plus extant industrial use with existing site access. The assessment case, base plus the appeal site, A, with existing Wates Way access, and B, the appellant's proposed 3-stage signal operation. And the assessment case alternative scenarios, which was a 4-stage signal operation as requested by ECC, with single sensitivity test, and the sensitivity test to allow Ongar Road to run twice during the cycle, which was called the sensitivity double. The AM and PM peaks were modelled. There was no local plan base model for the weekend. It was agreed that the sensitivity double would not be appropriate and it was not considered further. The results of VISIM modelling show for both the signal scheme and the single sensitivity case that there would be an increased average delays and lower average speeds than the reference case in both the AM and PM peaks, with the sensitivity single being worse than the signal scheme. The VISIM modelling also shows that the VISIM modelling also shows that the throughput of vehicles decreases in both cases with development trips, particularly in the PM peak and for the single sensitivity case. Similarly, increased journey times are shown in both cases. The mediation modelling also shows that with the signals, there are times when traffic blocks back from Wilson's Corner through the appeal site signals, and also times when traffic blocks back from the signals along Ongar Road to Wilson's Corner, which impacts on the operation of Wilson's Corner. This is explained in more detail in my evidence. The report explains that LINSIG does not appropriately model the complex interaction between the junctions, because traffic will be arriving at the northbound stop line under suppressed demand conditions after being held up at Wilson's Corner. The Stantec report identifies that the VISIM modelling with the signals considers a worst case. ECC considers that it's a robust case for the reasons set out in my statement of evidence. The report concludes that the network operates under severe delay to such a degree that vehicles are unable to enter the model network with a 4-stage signal operation, and that there are significant delays when traffic signals are added to the network. The mediation report concludes that it is clear that the submitted signalised junction in its current form causes delays and blockages, in particular on Ongar Road, that may prove unacceptable if traffic growth set out in 5.1.1 occur. These traffic growth assumptions relate to the appellant's own TA figure of 70% of food store trips being new to the network. The appellant did not provide any amended flows with the alternative assumptions until revised VISIM modelling was provided as part of their statement of case. The appellant's revised assumption that only 30% of food store trips will be new to the network is considered to be much too low for the reasons set out in my evidence. Also, the appellant has merely deducted 40% of food store trips from the wider network with no consideration as to where the trips are being diverted from. It is therefore not realistic to apply a reduction to the food store so that only 30% of food store trips are added. The Stantec mediation modelling also clearly shows that the scenario with existing Wates Way junction has the least impact on the wider network, including Wilson's Corner and Ongar Road, which is ECC's preferred option for the site access.
Just pause there, and I suppose we have a note I put in about the numbers. Now this relates to the general time point that you have already mentioned in the vision modelling. And as I introduced it, we have a model which is carried out by the Stantec mediation process, producing a reference case. You can see that sort of the middle of this table. With the requirement as an existing access. The signal scheme, which has 70% new traffic, with 30% being pass by. And then added here is their sensitivity single figures. And then just skipping across to sort of the shaded areas to the right, that the SCP model that you mentioned came in with using the 30% new traffic and 70% pass by, with 2 variations on the signal. So we've got sort of 5 columns. In terms, though, of the routes, those are all in the Stantec report outstanding.
That's right. Yes.
Are there any particular ones more important than the others?
It's the. I think they're all as important as each other, really, because it's all on the network, and they all feed into Wilson's Corner, which is the key area of congestion in Brentwood, the whole of Brentwood, actually.
Thank you. And then obviously you have hopefully highlighted the ones where the travel time is going to be 90 seconds or more increase. And obviously the variations in that depends on which scenario we're using. The conclusions you've been drawing in your proof, I suppose what you would place most reliance upon is which scenario?
It's the Stantec single sensitivity, because that's the set of signals which requires the 4-stage operation.
I'm going to stop you there a second, just for clarification. When you say the appellant proposed a 3-stage signal operation, you mean north, south, east, west, pedestrian? Or is it more complicated? I just need to understand.
It's very straightforward, actually. It's the main road, so it's Ongar Road together first,
Yeah.
side roads together,
East, west.
pedestrians, yes.
Got that. four-stage sensitivity single requested by you, which is
Side roads running separately, same but side roads running
the
separately.
side roads
Yes,
separate.
and then the pedestrians follow the side roads.
Okay. Sensitivity test on non-revenue twice, drop. Okay. Okay. And suppressed demand.
Suppressed demand, it means that the network is very, very congested, and therefore the traffic can't travel through junctions in free flow conditions, and therefore they're sitting at the back of the queue, so they can't say in.
They've got several cycles before they get through.
No, it's more in terms of general traffic flows on the network generally without the signals. Is that well, I mean, it does happen obviously with signals as well, but the suppressed demand is basically that there's long queues that can't actually reach that signal, so it can't get through. So you haven't actually totally accommodated the amount of traffic that you really need to, because there's traffic at the back of the queue that hasn't been able to go through the junctions.
I'm sorry to interrupt you, but
Not at all.
important enough. Get some idea.
If you create extra capacity, instead of it being a completely linear process, or suddenly that extra capacity is taken up by what was on the network
That couldn't get through, yes.
Thank you.
The question I suppose was just generally ask I suppose the scale of the sort of increases. Mr. Budd's figures are sort of only short a few, more accurate. Compared to 90 seconds, it's justifiable 10 or 20 above. But with the sensitive to single scenario, we're starting to look at figures like 332 seconds or 349 seconds or 160 or even 677. I mean, how does that go experience? I mean, what's the sort of reality of that?
That is basically that your queues get longer and longer and longer, and you get more and more congestion, and just more delays to the network generally, and probably a lot of driver frustration as well.
And in terms of a measure of the effect, is it just journey time that you're looking at, or other factors as well?
We look at journey time is the predominant one that you do look at. If you're looking at a VISIM model, that is the key factor. That's the industry standard to assess whether the network is operating satisfactorily or not. And journey time is used to validate a VISIM model. That's what's used to calibrate and validate the base models. So that is the main one. We also look at throughput of vehicles to see how the network is coping, and if there's a reduced throughput, that obviously means that the network is not coping because you're getting less vehicles through the junctions in that demand period. And there's also other things such as latent demand and average speeds that looked at, and that's in table 1 of the VISIM modelling report. Sorry, it's the Stantec report, and I do refer to that in my evidence.
Thank you. So I suppose, just following through, if something is greater than 90 seconds, would that concern you just at that level?
Yes.
What scale are you looking at?
90 seconds or greater is of concern, because obviously that's a significant increase in journey times. But when we've got increases of 677 seconds, that's a lot.
We have to get used to talking in terms of severe impact in policy terms. How does that equate? How does one translate from saying it's a significant impact into the policy effect?
It's, you have to look at everything together. So you have to look at the increase in journey times and the increase in the decrease in network and the decrease in average speed together. And so the overall impact to the network, you would look to see whether the impact is so sufficient that it's severe. There's no actual definition of severe, and it's a matter of judgment. And in a congested network such as this, that there is no additional room because the vehicles are queuing already, so vehicles are just adding to the back of the queue.
There's anything else on the figures? I think you've obviously covered it, but put the table to one side from that. And if you could go to your section on the impact of site access junction of 514, if you pick up that.
Yep. LINSIG capacity analysis has been carried out for the appeal site access. The TA considered both a 3 and 4 stage signal operation. Subsequent LINSIGs have only considered the appellant's proposed 3-stage operation. ECC has concerns that the modelling does not account for suppressed demand, the interaction of Wilson's Corner, parking on the approach to the junction, and assumes an unrealistic distribution of store traffic. The TA shows that for a 4-stage operation, which ECC requires for safety reasons, the signals require a long cycle time, which can lead to safety issues for pedestrians. Running a shorter cycle time would increase queues and delays. The updated LINSIG analysis for the revised geometry, which is 3 stages, has only 4.5% and 0.9% in the PM and Saturday peaks respectively, with the pedestrians called every cycle. The proposed signal junction would therefore be very close to capacity, and there is likely to be a significant reduction in the capacity for a 4-stage operation. The detailed design signal drawing shows a 4-stage operation to allow the right turn to clear. Running the side roads together would add another 5th stage and reduce the capacity still further, as would modelling the realistic situation with storage for for 2 right-turning vehicles in front of the stop line. The LINSIG modelling assesses the site access junction in isolation and assumes an equal distribution of traffic demand across the hour. This does not appropriately model the complex interaction between the junctions and severely underestimates the queuing and delays. The TA analysis for the William Hunter Way mini roundabout modelled it as a compact roundabout. The revised Arcady modelling for a mini roundabout shows that the appellant's proposed mitigation makes very little difference to the capacity of the junction, and therefore ECC does not consider that this would be of benefit. It is suggested that a condition be imposed to require submission and approval of a scheme to mitigate the impact of the proposals on Ongar Road, William Hunter Way Junction, and prevent the opening of the store until the approved scheme is implemented, although these improvements would not in themselves mitigate the full impact or resolve the first reason for refusal in relation to the adverse impact on the highway network. ECC considers that there would be an unacceptable impact on Ongar Road and Wilson's Corner with the introduction of the signal junction for access to the site. ECC believes that the cumulative residual impact on the appeal proposals on the operation of the network in the vicinity of the appeal site would be severe.
Thank you. I know there are some points that Roger we have to come back to, so it's just separate. So perhaps you could deal with the potential mitigation. I suppose this is slightly overlaps with the line 6, but it is perhaps just worth introducing that since we're open.
The appellant is not proposing any mitigation of the impact of the development proposals on Wilson's Corner. Should the inspector be minded to allow the appeal, mitigation of the impact on the highway network would be required. Brentwood Cycle Action Plan identifies the A1023 Shenfield Road as a potential flagship route between Brentwood and Shenfield to encourage mode shift from car to bicycle for all trips, including commuter trips. Route 25 is a segment of this route between Sawyers Hall Lane and Crescent. That should be Crescent Drive, not Crescent Road. Although the provision of this cycle route would in no way mitigate the full impact of the development on the highway network, it may go some way towards reducing vehicular traffic travelling through Wilson's Corner. A contribution of £450,000 has been requested for this based on a cost of £1 million for the route. That should be £1 million per kilometre for the route, of just less than 0.5 kilometres in length. A travel plan and associated monitoring fee will also be required. I understand that should the inspector be minded to allow the appeal, a package of Section 106 contributions, index linked, would be required as set out in the Brentwood Local Plan IDP to mitigate the wider impact of the site. These are set out in 6.68 of my evidence, although at the time of writing this evidence, it has not been agreed by the appellant.
Obviously, that's essentially how I think we'll leave that providing solicitors, the statement on ground was written after
Yes.
the agreement for one, and obviously that will be agreed as important as it is. So, happy to leave that at this stage. If we deal with the highway safety evidence, and it's obviously overlaps with what Ms Henderson was saying, but hopefully we'll be able to parts of it fit together. Please, your 6.1, please.
ECC believes that the introduction of traffic signals for the proposed appeal site access will lead to an unacceptable impact on highway safety. Ian Henderson's evidence deals specifically with the road safety audits for the signalised junction from the perspective of a road safety auditor. My evidence deals with the implications of ECC's outstanding safety concerns. ECC undertook two Stage 1 RSAs, one in November 2021 for the scheme that is the subject of this appeal, and one in January 2020 for the 2019 planning application. Concerns regarding the safety of the proposed junction were consistently raised by ECC throughout the consultation period. The appellant has submitted 4 RSAs for the proposed signal junction. The first 3 all raised issues, some of which are still outstanding, and the 4th Stage 2 audit raised no issues at all, which is of concern as it does not address issues raised in the previous audits and does not pick up obvious safety issues within the current scheme. The outstanding RSA issues are discussed in Ian Henderson's evidence. The implications of these safety issues are set out in my main evidence and can be summarised as follows.
Just want to also say, obviously, it's fairly fresh in people's minds, obviously, when you're ready to prove,
No.
So, probably in your hands, but I thought there were some of these points that we could really take as read, even though they're the summary of it. So I think it might do something. And I suppose, just broadly speaking, in terms of what Mr. Henderson has done, do you agree or disagree with what he's produced? And the question then is, what have you done with his report?
We agree with his road safety audit because the auditors are very experienced auditors, and we have to take into consideration safety concerns. As I said before, we've got a responsibility to make sure that highway improvements, not only by developers but also by for schemes that are implemented by Essex County Council themselves, are safe and have all these safety issues that have been identified have been mitigated. So we do take that very seriously, and it does inform how we would consider a development proposal overall.
Thank you. I think with that in mind, we probably go to the last part of this section, where you, having dealt with a sort of number of points, you pick up point about parking on Ongar Road and North Road, and that's something that hasn't really been discussed very much. You pick up at, I think it's 617.
Another safety concern is that vehicles regularly park on Ongar Road and on North Road despite the double yellow lines and the peak hour loading restrictions. Up to 8 vehicles are regularly parked on the southern side of North Road in the vicinity of the fast food takeaways in the evening peak, meaning that vehicles turning in from Ongar Road crossing the centre line so that oncoming traffic would have committed to passing the stationary vehicles have to mount the footway to pass them. The introduction of traffic signals is likely to exacerbate this problem. There are also safety implications associated with the additional queues and delays at Wilson's Corner Junction, long queues and delays can lead to driver frustration, which can lead to drivers trying to enter the junction in too small gaps, leading to collisions. It can also lead to vehicles queuing over the pedestrian crossing carpets, with consequent risk to pedestrians who may cross when it is not safe to do so. ECC therefore considers that there would be an unacceptable impact on highway safety, both for pedestrians and motorists, and the impact of the introduction of signals the impact of the introduction of the traffic signal junction for access to the appeal site would be severe.
Can I just pause there, because you introduced the point there about the congestion on the network, not just as we're looking as Mr. Hampson was, a specific junction. How do the two relate? If you've got, I suppose, a report from an RSA about what happens at the junction, which, as we've heard, is more sort of objective. How does congestion affect how you look at that, or not? Or where are you looking at the congestion? Is the junction itself, or what?
It's everywhere, really, because we have to consider the whole proposal in the round. Obviously, congestion does impact on the junction itself, because where you've got traffic queuing through the junction on a regular basis, like we have at Ongar Road in the vicinity of the appeal site, that does affect how the junction will operate, and therefore it in itself may have safety implications. If it was free flow, there would be different conditions to a junction where there are very, very regular congested conditions with queuing.
Thank you. Probably worth just completing your summary. As I said, there are the points that we picked up in the rebuttal that are very specific. As you want to turn to those now before coming back to other issues. So you're sort of being led by me, perhaps. Well, should we deal with it now, so it all fits within the sense of the topic? Mr. Buzz in his rebuttal, sorry we're using quite a microphone, people hopefully can hear me. just turn my on to perhaps ask you. You gave an explanation about why you consider you did understand the information that had been submitted. Could you, I suppose, just confirm when you received the information and your paragraph 2.10 of your proof says the appellant confirmed that trips across the network had been reduced such that only 30% of the food store trips were added to the network. I'm just quoting 2.10, and that no trips have been reassigned from other routes. What was the broad concern there? Because obviously he's, as Mr. Rudkins has suggested, there should be a lower generation of new trips. But is it more than that that you're criticising?
It's the fact that we don't accept the VISIM modelling, the new VISIM modelling, because there are various reasons why. So it's not just the trip matrices. We think that 30% new trips is far too low altogether. There is no evidence for why 30% new trips has been used. The appellant has quoted the TRICS report 14/1, which does say that there will be some trips that are already on the network. It doesn't identify what proportion. We feel that, and as reported in the TRICS modelling report, that convenience stores have less secondary trips because they've got a lesser range of facilities. So convenience stores would have far less secondary trips, and by secondary trips I mean pass-by and diverted trips combination. There is no methodology or no evidence behind picking 30% for new trips. The report, the TRICS report, recommends a methodology for surveys to identify the types of pass-by and diverted trips from existing stores, and it says that you should use questionnaire surveys at existing stores on similar kinds of locations to identify the proportion of trips that are passed by. So they would have been passing directly by the site access, and the proportion that would be diverted, so where they would have been diverted from and where they'd been diverted to. There's no evidence of that the surveys that are quoted in the transport assessment from the appellant just basically look at traffic flows past the store and in and out of the store. There's absolutely nothing to say that questionnaire surveys were not undertaken. So there's no evidence to back up the proportions that have been used by the appellant. Yes? Sorry?
Can I just follow on? Is it simply a disagreement about using 30% as the new trips or 70%? Or is there anything about the revised VISIM model that Mr. Budd has submitted beyond that? Is it simply that, do you put in 30 or 70, or is there anything else about what's been done in terms of his assumption about traffic in that model?
sorry. The Stantec model is based on, I think, on version 11, and the appellant's version is a newer version. And although, you know, it's basically the same, there have been some updates to it, so it's very difficult to compare like with like, because they're different models of the versions of the model. So ideally what should have happened was that the appellant should have used the same version of the model as a Stantec base, so we could compare like with like to see what difference it actually makes. And
When we say 30 up to 70% new trips, do we mean new trips in that area or new cars on the road that would not have made that trip previously?
it's quite complicated.
Try.
Let me try and explain. It is very important, actually. It is new to the network that we are testing, basically. So that's why the difference between pass-by and diverted is important, because pass-by are the trips that are already, in this instance on Ongar Road, it is the trips that are already travelling on Ongar Road, that instead of, say, travelling southbound past the site, would change the trip, go in and out, and then diverted is the traffic that would have been going somewhere else. Yes, and therefore have changed their trips, changed their routing, so that you would still get new trips on Ongar Road because they would have been going somewhere else, so they're new to Ongar Road.
Sorry to interrupt again, guys.
I think it's important.
Hopefully that puts it in context. And can I then pick up another point that's made slightly later in the rebuttal? So 2.7, when Mr. Budd refers to there being an alternative standard and a diagram he shows from what is the traffic signs manual as an appropriate standard for the design of the junction for the use by HGVs. Now, you touched on why you would still use the design manual for roads and bridges, but what is, in this context, the relevance of, I suppose, what the traffic signs manual would suggest is a way forward? Some of these points you've clearly covered, and can I just pick out there's a reference at 2.16 to the Stantec results being summarised as misleading. Do you see that? You've obviously been relying to some extent on the Stantec Visim results. What's your view of the way they've presented it?
I agree, actually, that I do apologise. I keep forgetting. The other cases that are referred to in the Stantec report, the existing site access, the signal scheme, the sensitivity, and the double sensitivity, obviously don't. Sorry, what am I going to say? Forgotten what I was going to say then. Oh yes, it was the other cases. Sorry, I've lost my train of thought. The existing access case does take into account the little traffic generation that pass by, and it still shows a decrease in performance of the junction. And even if you do deduct the pass-by trips from the base flows, then there's still a couple of approaches that have over 15% reduction in flows. The Ongar Road north to south has 15% reduction, and the North Road has an 18% reduction with the signal scheme. That's between 5:30 and 6:30.
There's a series of points there, but it's, thank you. We're going to have to do it one by one. Perhaps when you finish, you turn yours off. We'll see how we go. But let's say, just picking up a couple of points. At 224, Mr. Budd mentions that you appear to dismiss the benefits of using the acronym MOVA approach, the vehicle actuation of the signals. In that you state that it does not increase capacity but merely optimises performance. Are you suggesting that vehicle activation should not be used, or what is it, the point you're making?
Absolutely not. We accept that mover would be advantageous to implement at the signal junction. The mover, as I said in my proof of evidence, doesn't increase the capacity of the junction itself. It optimises the operation of the signals within the practical physical constraints of the junction. It's things like the lane widths and the saturation flows, which means the amount of traffic you can get over the stop line per cycle, and the radii, corner radii, the turning movements that actually dictate the actual capacity of the signals. But mover does help optimise the operation of those signals, so it does work. How it works is that within a signal cycle, there's a minimum green and a maximum green, and it can identify through the detection whether there's any periods where there's not a demand, and then it can stop that cycle anywhere between the minimum and maximum green, and allow another stage to run. So in a fixed cycle, you've got, say, a 90-second cycle time, and that each arm runs its cycle, but mover allows a different operation of the signals to maximise the capacity within those constraints. However, in congested conditions, if there's a demand throughout that whole period, obviously there's not the opportunity to, like Ongar Road north and south has got a far higher flow than the side roads. So if there's not those opportunities for gaps, it will continue to its maximum green. And also it does not stop platooning, because one of the issues that's been identified through the VISIM report is that the traffic signals from the site access junction introduce platooning of traffic, so vehicles are held back at the stop line and released in a bunch rather than individually, and that is what causes the issues at Wilson's Corner, because it then impedes the movements at Wilson's Corner, and then that's got a knock-on effect on the traffic coming up northbound on Ongar Road as well.
Could you just explain how platooning in one direction affects what happens in the other?
It's explained quite well, actually, in the Stantec Visium modelling report, and that is the fact that because you've got a lot of traffic bunched in effect and all arriving together, that from the traffic from Ongar Road in the platoon impedes traffic from Shenfield Road, so there's not as many gaps for the Shenfield Road traffic to enter, and that in effect has an effect on the Ingrove Road junction, which in effect has a knock-on effect on the High Street junction, and because of the blocking of the whole junction, it then means that you get platooning on the northbound, Ongar Road northbound.
Can I then touch on one further point about what the local plan looked at? Because there have been some comments made by Mr. Budd about what reliance you've been placing on it. For instance, here's 249 of the rebuttal that you had commented the local plan modelling did not allow for the appeal site, did allow for it, but not with a signalised access. And he says he's surprised that you did not provide details of what was allowed for in terms of trip generation and the rest. Now, what did the local plan modelling consider when this site was allocated? I suppose, therefore, what relevance is that to what we're looking at now?
The local plan obviously looked at the local plan allocations at the time, and the local plan allocation was for some kind of commercial and residential units. So in that respect, it would have been included in the local plan modelling, but it would have used the existing site access junction, which is a priority junction to the existing Wates Way industrial estate, rather than a signal junction. And it does very high level kind of analysis in terms of looks at the overall impact of the development proposals which are being examined as part of the local plan to see whether the development impact, to look at the impact on the network as a whole, and then identify the mitigation. And it would identify if there's any showstoppers in terms of where the sites are allocated, and then if because the modelling's done at various stages, and if at the first stages it shows there'd be an unacceptable impact from a local plan site allocation, it probably would be excluded, and therefore when the plan is finalised, so the spatial strategy kind of thing for where they're going to go, it would help inform where your sites are going to be located. And at the more detailed stage, it's to look at the overall impact of the site allocations as a whole and identify the mitigation that is required for that as a local plan. In the local plan, there's also a requirement that as the sites come forward, that individual sites need to be looked at for their more detailed impact on the network through the transport assessment for that individual site access. And as I said before, the difference between the local plan and the development proposal is this is now a proposed signal junction.
Thank you. I think there's most of the points you've otherwise dealt with. There is just a stray point that's arisen when looking at the your chapter 7 and the I suppose there are a couple of points in the rebuttal. 2.54 well, sorry, I should start 2.53, that it comes back to the point that the RSA may have identified some issues with the turning of vehicles of HGVs, but little only, they say, generate 2 a day, and there would be a condition about deliveries. So if it's not a realistic scenario, why is it a consideration here? What's your response to that? Sorry. It happens from time to time, giving evidence to. This is moving topic, and it's about the identification of an issue with the turning of HGVs into the appeal site and out of the appeal site. The reference point is 2.53 of Mr. Budd's rebuttal. And they're basically making the point, well, you might be able to point to that on a plan, but it's only 2 HGVs a day. So why is it a consideration?
I'll repeat that. It has to be a consideration because even if it's 2 to 3 heavy goods vehicles a day, it's still got to be a safety consideration because it's, you know, they could lead to collisions within that time period. So it's still an important consideration.
Thank you. The next paragraph deals with a point you've made regarding, I suppose, waiting in the junction, and it said you don't have knowledge of yellow box markings, and it said that vehicles cannot enter yellow box if their exit is not clear, but because we're not, I think it's, they said the Little Access and North Road are never going to experience queuing traffic to the extent it would prevent outbound traffic. So, firstly, do you follow the point he's making about yellow box markings? And secondly, why are you still concerned about traffic having to turn?
You need a decent lawyer. Do you know it? No.
But it,
Sorry. Okay, that's news to me, I must admit.
yes,
So you can wait in the yellow box marking
to
if you
return.
make a turn.
That's right. Yes.
It's only if you go straight through.
Yes. That's right.
Ah, Mr. Budd saying no. Okay.
Only if your exit is clear.
Yes.
You can't enter yellow box to make a turn if your exit is
Why
blocked.
would you wait?
Because it's not contract.
Then it's not clear.
At the exit.
You can enter a yellow box if you're continuing on your journey.
If you're turning right, you can wait there, even if there's traffic coming that way, as long as there's nothing blocking you when you get the gap to go. Yeah.
Yes. That's right. However, so you, in that respect, you can wait to turn right or left or whatever if your exit is clear within the yellow box markings. However, we would not advocate that you have yellow box markings on a junction like this with the right turn lanes marked, because there'd be too much confusion. You wouldn't be able to see the yellow the lane markings sufficiently with the yellow box markings. This was considered as an option to have yellow box markings very early on in the discussions with the appellant, and because of these issues of the conflict with the lining for the right turners, it was actually discarded, so it hasn't been taken forward. But it does have an impact on the modelling, because obviously vehicles queue through the junction and then cause disruption to the operation of the signals. And people do get frustrated and people do queue through signal junctions because if they're in a queue, they just continue in the queue and they're stuck in the middle because the lights turn red while they're in the middle of the junction.
Sorry, I didn't mean to hold you.
So it's a series of straight points, so at times we need to be careful how we introduce them. And basically saying it was considered but rejected, but it has had an effect on the original modelling about what was assumed.
That's correct, yes it has.
This question might be, where do we stand now in terms of modelling we're looking at?
The model we're looking at in terms of the revised modelling from the appellant, that it uses the same base as the original Stantec modelling scenarios. So that puts in the yellow box markings as well, because it's just the flows that have been changed from the original Stantec modelling that was used to assess this application.
The final sort of straight point, it's again because of little sort of identification of specific problems. We have an illustration of an HGV in the rebuttal, and just wanted to pick this up about it's 2.58, and it relates to the swept path assessments and why you especially don't appear to. It suggests you really haven't taken account of the fact that if you're worried about mirrors colliding with pedestrians, you need to remember where the mirrors are on an HGV, and they're very high. I think that's essentially the point that's being made. Given that, is there still a concern in your consideration that the swept path assessments would pose this risk to pedestrians?
The curbs have been increased, taken out to increase the footway widths on the southern side of Ongar Road. That leaves very little room for two HGVs to pass, and there looks to be on the swept path less than half a metre, so that would be a clash with mirrors. So potentially that would lead to vehicles potentially mounting the footways to either colliding or mounting the footways to avoid an HGV travelling in the other direction. And on site, there's a pedestrian island on that approach at the moment, and it's very clear from looking on site that the bollards, the keep left bollards, have been knocked over, showing how tight it is already. And with the curbs built out, it'll be even tighter. So that's a concern for that approach with the alignment as proposed.
I think we could leave the road safety points there in your evidence, Chief. There are obviously other points raised, but I think you covered them in your evidence. Can we then move back to the other parts of your evidence we hadn't covered in your summary? Essentially section 7 onwards. First of all, you deal with the concerns about air quality. Now, so partly in your hands, but I'm aware that obviously local residents have raised concerns about it, but we could leave this till a general discussion on air quality, or we could deal with it now, really in your hands.
Well, bearing in mind the appellants aren't putting a witness forward on air quality as such, I think it's probably fairer we leave it to the round table. Yeah?
Very happy to do that way, yeah.
Sorry? Ah, right, okay. No, I'll deal with it in round table on Thursday.
Which is we move to your section 8, which deals with this point about the utilities around the junction and what could or could not be built, which is worth, I suppose, explaining why there is still a doubt about this. Can you 8.1, please?
I do apologise. The fourth reason for refusal relates to ECC's concern that the appellant has not demonstrated that construction of the signal junction is achievable due to the presence of utilities apparatus, or that the signal equipment could be located within the footways, which are already likely to be congested with utilities, whilst maintaining sufficient width to accommodate pedestrians safely. Most of the footways surrounding the site are currently below the minimum recommended 2 metres. The presence of utilities in the footways may result in narrower footway widths in the vicinity of the signal poles. This could result in pedestrians stepping out into the road, which would be detrimental to highway safety, particularly for pedestrians. The signal installation may not be achievable due to the high costs of diversions because the utility companies may not agree to the diversions, or because the utility companies may not agree to the diversion works that would be required. ECC has repeatedly suggested to the appellant that they would need to carry out trial holes to assess if the signal equipment can be satisfactorily located in the footways. The appellant has not carried out trial holes, and as far as can be determined, the appellant has not held any discussions with the utility companies to ascertain the cost and feasibility of any diversions. ECC does not consider the appellant's surveys and C2 utilities information together provide enough detail to assess whether the signal equipment can be accommodated for a number of reasons as explained in my main evidence. ECC requires the appellant to fully explore the possibility of delivering the infrastructure within the footway first, because the alternative is to deliver it within the carriageway. Diversions in the carriageway may not be feasible due to the prohibitive costs and may not be acceptable to the utility companies. ECC is concerned that diverting existing statutory undertakers' equipment in the footway may not be possible at all, and even if it is physically possible, which has not yet been demonstrated, it would come at a prohibitive cost given the limited space in the amount of equipment which is likely to have to be diverted. In this case, the highway is so constrained that should diversions prove not feasible, alternative access arrangements at the proposed locations are not feasible, and there is little or no room for amendments to the proposed junction geometry. The only possible alternative would be to use the existing Wates Way junction, which is ECC's preferred location. However, this would not be a feasible option with the site layout as it is, which is the subject of the appeal, and the appellant has rejected this as an option for access to the appeal site. ECC considers that, given the concerns, the appellant has failed to demonstrate that the signals would be deliverable. Should the inspector be minded to allow the appeal, ECC and the LPA consider that these issues could be dealt with by way of a Grampian-style condition to ensure that these matters are resolved and the new access is delivered before any development, except demolition, can take place at the appeal site. ECC therefore suggests that such a condition could overcome this reason for refusal.
Thank you. Do you want to just pause your mic there?
Sorry.
You then have a section on policy standards and compliance. I suspect we can take that as read, because obviously you then compare it back to the standards that apply that you say still are relevant, and obviously to the NPPF. So I don't think you need to summarise that. And then you have a conclusion section, which obviously brings the various elements together about all the different factors. Again, I think by this stage of the inquiry, people understand that you still consider that the reasons for refusal remain. Is there anything else that you wanted to pick up at this stage? I know I've probably taken that a bit rapidly, but I'm grateful. I think therefore, so would conclude the evidence in chief.
I would suggest probably that's a good time for a 10-minute break before we crack on. One question for the council at this point, I should have done earlier. Can we leave documentation in this room tonight? There's a right answer and a wrong answer to that question. That's all right, as long as, I mean, let's be honest, it's got to be pretty sad to want to nick this lot. So, okay, that's great. As long as we don't have to move everything out, that's great. Okay, thank you. Right, back here in, well, what, 1:45? Thank you. welcome back everybody. Inquiry resumed. Mr. Taylor.
Sir, thank you very much. Good afternoon, Mrs. Gore. I'm going to start by just asking some questions that are really just about clarifying various points. They jump around a bit, so you'll have to forgive me. Starting, please, with the Essex County Council position in relation to the allocation of this site for a mixed-use scheme. It's right, isn't it, that there was no in-principle objection to the allocation of the R15 site for a mixed-use scheme, including a supermarket of the scale, in fact, slightly larger than that which is proposed in the appeal scheme. That's right, isn't it?
Insofar as it's a local planning authority plan, Essex County Council didn't do the traffic modelling for the local plan. It was Brentwood's own modellers. But in terms of the overall comments, in principle, no, that's right. There's no objection.
And as part of the representation that ECC made, I think I'm right in saying that they didn't at any stage say that a scheme couldn't come forward if it included a signalised junction.
To be fair, at the local plan stage, you don't go into that kind of level of detail. It's just the in-principle site allocations and the impact of the overall allocations on the traffic, on the capacity of the network generally, rather than the details of the types of junctions that would be provided for each site allocation.
Yes, I'll ask my question again, if you don't mind. The examination that R15 could come forward as long as it did not include a signalised junction. That's right, as a matter of fact, isn't it?
That's a matter of fact, but as I said, you don't get into that kind of level of detail at the local plan stage.
Thank you. And we can also note, can't we, that the local plan is supported by an infrastructure delivery plan.
Yes, that's correct.
And it's correct, isn't it, to say, as I think Mr. Budd does in his proof of evidence, we turn to his page 76. He says there are no scheme proposals listed within the IDP that refer to mitigation works to either the junction of William Hunter Way with Ongar Road or to Wilson's Corner. And so, because those were omitted, it must be concluded that the Council and the Highway Authority were satisfied that the redevelopment of site R15 can come forward without prejudice to the operation of the wider local highway network. I'll let you turn it up. So he notes the absence of proposals within the IDP relating to mitigation works to either the junction of William Hunter Way with Ongar Road or to Wilson's Corner. And he says, by their omission, it must be concluded that the local planning authority and highway authority were satisfied that the redevelopment of site R15 could come forward without prejudice to the operation of the wider local highway network. That must be right, mustn't it?
I disagree, actually, because the reason that there was no mitigation identified in the IDP was the fact that a scheme hasn't been identified. The transport assessment is very clear for the local plan that there is an impact of the local plan growth on the network, particularly on Wilson's Corner, and therefore some mitigation is required. and they did look at various options. They looked at turn bans, they looked at one-way system, including Middleton Hall Lane, and they looked at signalisation in Wilson's Corner, but they didn't come up with any mitigation at that time, which is why they have identified that further work is done between the Borough Council and Essex County Council to try and identify mitigation for Wilson's Corner, because they identified that it was needed as a consequence of local plan development. The IDP is an ongoing thing and can be updated as regularly as necessary, and therefore schemes can be added as and when they're identified for that mitigation, because it's very clear in the TA that mitigation is required.
There's nothing in policy R15, is there, that says that mitigation of those two junctions, as I've just referred you to, is necessary as a result of the anticipated development coming forward in that allocation?
R15 doesn't mention junctions specifically, but it does say that mitigation will be required as required by, I think, I'm not sure if it's just the Highway Authority or the Highway Authority and the Local Planning Authority. So it does say that mitigation should be provided.
I think this is the simplest way. Your summary proof, page 10, paragraph 519, having said in 518 that the revised architecture modelling shows that mitigation makes very little difference to the capacity of the William Hunter Way mini roundabout. At 519 you say it's suggested that a condition be imposed to require submission and approval of a scheme to mitigate the impact of the proposals on Ongar Road, William Hunter Way Junction, and prevent the opening of the store until an approved scheme is implemented. What is the mitigation scheme that's necessary?
The mitigation scheme hasn't been identified. This came about because in the transport assessment, the appellant identified the mitigation was necessary or at that junction, particularly in the Saturday peak, because that was the worst peak, and proposed that the mitigation would be the provision of a compact roundabout. The compact roundabout cannot be implemented because the ICD of the roundabout is only 22 metres, and you can only have a compact roundabout if it's 28 metres. There's not physically enough space to do a compact roundabout. Therefore, it would be a model wrong. And when we very recently asked the appellant in our statement of case for additional modelling because they hadn't done the modelling correctly, and that modelling showed that with a mini roundabout it doesn't make very much difference to the capacity at all. So because we haven't had any more discussions with the appellant, it's only identified that that's not relevant. We haven't actually got to the next stage of what would actually work at that junction. But we've identified that some mitigation is required there. The appellant identified that themselves.
Second, you said that a compact roundabout had to be 28 metres, did you say?
The maximum diameter, the minimum diameter for a compact roundabout is 28 metres ICD, so it must be at least 28 metres, because otherwise vehicles cannot turn round it.
Where do I see that stand?
CD116, which is DMRB, but that is the only standard for roundabouts in terms of the technical details, and it does set out, and there's diagrams in there which show what ICDs are required for what size of vehicles.
Okay, well let's just deal with the DMRB since we're on it. Thank you. Mr. Budd's rebuttal And his page 6 of the rebuttal, paragraph 2.7, he says that ECC uses the design manual for roads and bridges in addition to internal guidance for assessing highways proposals. He refers to you saying that there aren't geometric design guidance for junctions such as signals and roundabouts in manual for streets. He goes on to say that his view is that manual for streets 2 and the traffic signs and manual chapter 6 2019 are the appropriate reference for junction and highway design within built up urban areas. He goes on to look at what the DMRB says about itself in its introduction under the heading application of the DMRB at paragraph 2.1. All works, including inspections on motorways and all-purpose trunk roads on land owned, leased or managed by the overseeing organisation, shall be undertaken in accordance with the DMRB requirements appropriate to the intended use of the asset or road. So he says the DMRB is designed for roads of higher status than those under consideration in the present case. That's right, isn't it?
That's correct, but individual highway authorities can apply their standards, because it doesn't have to be just National Highways that applies that to strategic trunk roads. It can be local highway authorities that apply those, and Essex County Council doesn't have the technical guidance for all types of junctions, and therefore our design guidance is DMRB for quite a lot of the aspects, including roundabouts.
It goes on then to say that there's a danger that if the DMRB's advice is followed, over-engineered solutions will result. And so the guidance in manual for streets or designing streets is to be preferred. And indeed he says the DMRB itself explains that at paragraph 2.1.1 in the introduction. In the context of detrunking, it says where the road is to be reduced in status, e.g. detrunked, or where works are carried out on roads that are not part of the trunk road network, and the use of the DMRB could result in significant overspecification, alternative documents such as manual for streets or designing streets may be used with the approval of the overseeing organisation. Here, isn't it, the DMRB itself says be very wary of using the guidance in the DMRB itself in a context to which it's not intended to apply.
Which is why we do apply manual for streets in terms of visibility in areas like urban areas. We do apply manual for streets there. But as I said before, the detailed specific guidance is not there in DMRB for the technical details. Sorry, not there in manual for streets, and it is included in DMRB, which is why the County Council uses a combination of them, and we do use DMRB for the technical details.
And so to come back to your point, the simple point is this: there is no mandated standard applying to the status of the road that we're dealing with here that requires 28 metres, is there?
There is no mandated standard. However, there are physical requirements in terms of the manoeuvres that can be undertaken at certain size roundabouts. And DMRB does point out very clearly that you can only make certain manoeuvres at certain size roundabouts. And for it to be a compact roundabout rather than a mini roundabout, the minimum ICD is 28 metres. And the reason for that is a compact roundabout has a curved central island. A mini roundabout has a painted or a domed central island of 4 metres diameter. A mini roundabout has to be overrunnable, and therefore it's a mini roundabout. a roundabout with a curbed island is not overrunnable, and that's one of the features of being a compact roundabout. But if it hasn't got an overrunnable island, it must be of sufficient ICD, which is the total diameter of the roundabout, to allow all movements to drive through it that absolutely need to. The William Hunter Way mini roundabout, if you go out on site, is very, very clear, because there's a lot of damage to the central domed white island by vehicles overrunning it. It's got, for the northbound movement from Wilson's Corner through William Hunter Way to Ongar Road, it's broken away and severely damaged by vehicles overrunning it. So if that was to be a curbed island rather than a mini roundabout island, the mini roundabout domed or flat island, vehicles would be constantly overrunning. So it's just not suitable. Whether you know, we can be talking about the standards and DMRB and Manifest Streets, you know, all the time, but it's the physical capability of that junction to be able to accommodate the manoeuvres that it does. And clearly, this is not big enough to accommodate a curved island.
519 of your summary, then, the having rejected the mitigation that has been modelled by the appellant and identified that a scheme needs to come forward, what is that scheme? What effect will it have on the operation of that junction? And can it be delivered within the highway boundary?
That is something that needs to be investigated. Obviously, the mini roundabout proposals that the council put forward with the mini roundabout, we don't think would have very much mitigating impact at all, because it's just some
Right.
and it's probably something that would be linked to Wilson's Corner, because the two are so intrinsically linked and they operate together, that it would probably have to be something that combines the two. But as yet, because the regards capacity assessment was only submitted in TN06 with the up to the statement case, obviously we haven't had those discussions in the hasn't looked at what mitigation would be required and whether it you know, more suitable than the new roundabout they're proposing. But we haven't identified a scheme for it.
Essex has been discussing the redevelopment of the Peel site since what, 2016, is it?
The first pre-application is 2014.
Right. And having rejected the mitigation that's proposed by the appellant for William Hunter Way mini roundabout, it's correct that you sit here unable to identify a mitigation scheme that would do better, even though you've been looking at it for nearly, what, 8 years?
The appellant's been looking at it for 8 years. We have been assessing it, and it hasn't been constantly for 8 years. It's been on and off. We have consistently said that we have got issues with the site, and identified that things needed to be done. The one reason that we didn't assess the William Hunter Way junction proposals in any detail was because the appellant had not looked at the wider impact on the network. They purely looked at the signal junction of William Hunter Way, and because of the complex interaction between Wilson's Corner, William Hunter Way and the site access junction, we didn't consider William Hunter Way until we had the wider modelling. We have got the wider modelling now, but it's an ongoing process really to look at what is required for the whole mitigation package.
What single proposal?
We haven't suggested anything, you're correct, but when a developer puts in a proposal, it's excuse me, I need to drink water. It's down to the appellant to look at the impact of the development traffic and propose mitigation. It's not for the local authority to decide what's required and then tell the appellant what they need to do.
Do you think, Mrs. Gore, that the failure to identify anything in relation to mitigation for the Ongar Road, William Hunter Way junction, the total failure to identify any step at all could be described as approaching development in a positive or creative way, or could it be described as working proactively, or could it be described as seeking to approve the application where possible? Does it fit into that or not?
I think we have been proactive in the fact that we have been having ongoing discussions with the appellant since 2014, and the proposals have developed significantly since the 2014 application. The geometry of the proposed site access junction has changed, has been amended. We've had ongoing discussions. I think the mediation process that was carried out last summer was extremely useful, and that proactively tried to seek some kind of agreement between the parties. So I think we have done quite a lot actually to try and achieve agreement with this. We have suggested to the appellant that the existing access should be used because it's got far less impact on the network. But because a standard store doesn't fit on the site, I understand, and because of the impact on residential, that's not a consideration. So I think we have looked at various options, and we've worked with the appellant to try and look at solutions, really.
We're going to turn to look at the deliverability of the signalised junction, and I think where you get to in your proof is on page 62. And you say that essentially where you've got to now is that the issue can be dealt with by a Grampian style condition to ensure that matters are resolved and a new junction is delivered by a 278 agreement before any development can take place. And therefore you've suggested a condition, and I think if we look in page 62 of Ms. Gore's proof of evidence, paragraph 925 at the bottom of that page. And I think we've got to the position where a Grampian condition is proposed, and indeed there are two versions of one in the statement of common ground, I think it's condition 26. If we just have a look at that. So condition 26 in the statement of common ground, sir. It doesn't have a page number, helpfully. So it's in the conditions. It's right towards the back. It's about 3 or 4 pages from the back. So condition 26, I think, there are two versions. Yeah. Okay, so the first version is the council's preferred version. Development shall not be commenced unless and until detailed technical drawings for the proposed signalised access junction and the diversions have been submitted to and approved in writing. In addition, once approved, development shall not be commenced other than demolition and construction of the site unless and until the proposed signalised access junction has first been completed in accordance with those details. Now, you've got the appellant's preferred condition, which I think effectively allows demolition to take place in advance of the approval of the drawings. But I think that's the only material difference. Can you just explain why that condition couldn't have been imposed on the day when permission was refused?
Because it was an outstanding concern at the time, and that's something that we only recommend to the local planning authority. It's the planning authority to see whether they put that forward as a well, how they put that forward, whether they put that forward as a condition, and I think the reason was because we were very, very concerned about the deliverability of the junction, and therefore, because there were lots of other reasons that we were concerned as well about the proposal generally, it only seemed reasonable to include that as an issue and put that on as a reason for refusal, because obviously there were no conditions at the time if it's been refused.
If you impose that condition, and it turns out that the signals couldn't be delivered, no development could come forward, could it?
With the condition as we propose, that's right, yes.
And so, there would be no planning consequence if it turned out that the signals weren't deliverable. And so, the deliverability of the scheme, addressed by a condition, cannot form a reasonable basis for, and could not form a reasonable basis for refusal. That must be right, mustn't it?
I think the view was taken that because it was such a significant concern of the highway authorities about whether you could actually achieve it or not, because the application was being refused, it was included as a reason at that time, so that it was obvious that was a concern as well.
Thank you. Turn away from that issue and turn to questions about risk and safety. Now, Mr. Henderson was very clear in his evidence that the process that he applied to look at the highway aspects that he considered was not a risk assessment. You understand that? So, who is it at ECC who conducted the risk assessment following on from the advice that was delivered from Mr. Henderson to ECC on the 25th of November 2021, prior to the submission of the objection to the scheme by ECC to Brentwood Borough Council on, I think, the 10th of December?
In terms of the assessment of the implications of the development in total, as Mr Henderson said, that is down to the strategic development team to consider all the aspects together and to take a view based on the information that is given. And the road safety audit is obviously one of those considerations when we are making our decision.
When you made your decision, where do we see an assessment of the risk implications of the matters that Mr Henderson identified? Who was it who looked at the likely frequency of an event occurring or the likely magnitude of a consequence of an event?
In terms of risk assessments, that's not a standard part of considering a planning application. However, it doesn't mean to say that there are not safety concerns. As I said previously, the Highway Authority has a responsibility and a duty to ensure that all highway proposals, ours, Essex County Council schemes, as well as developer schemes, are safe. We have to consider the road safety recommendations and the safety implications that are identified within that and take a view. We have a very strict process to go through in terms of road safety audits and technical audits of schemes, whereby the risks, the safety problems, I know the risk is what you're after, the safety problems are identified and that they have to be mitigated to a certain degree. If they cannot be mitigated, we have to go through an exception report process whereby the, excuse me, the issues are identified in an exception report and they have to be signed off by our senior managers. And our senior managers will look at the mitigation that's proposed against those items and will take a view. If there are unresolved issues, it is very difficult for the Highway Authority to sign them off without any mitigation because the risk of any claims or any compensation falls back on the Highway Authority. And it's the consequences, not just it's not really the claims at all. It's the consequences of having collisions and personal injury accidents as a consequence of a scheme where we know there have been identified safety concerns through the road safety audit. So we take them very, very seriously. We don't, as you say, do a risk assessment per se, but that's not part of the highway standard for assessing any junction improvements or any developer schemes.
Right. ECC wrote an objection to Brentwood Borough Council saying that the highways issues that the application gave rise to justified refusal. Is that right?
Yes, that's correct.
And in so doing, am I right in assuming that somebody at ECC applied paragraph 111 of the MPPF?
We do take that into consideration in our recommendations, yes.
Right. And so that means that somebody, somewhere in ECC, had to reach a view in relation to the safety issues that the consequences of the appeal scheme were, or would be, such that they would give rise to an unacceptable impact on highway safety. Yes?
That's correct, yes.
Policy test requires an assessment of risk to highway safety, doesn't it?
which we considered through the road safety audit process.
So your evidence is that it was Mr. Henderson who assessed the risk of accidents arising as a result of the scheme coming forward?
Predominantly, it is the road safety audit that identifies the road safety implications, yes, and then it's the strategic development engineer that takes all the items together to assess whether whether the scheme is acceptable or whether we think that the impact would be severe.
To 10, let me just check my... Eventually my notes are going to give out and I will get a duff reference, or there'll be no reference at all. Or usually what happens is I can't read my own handwriting and read the reference out, which is a perennial problem. But I think if we start by looking at your 210, yeah. No, it isn't. Great. Yeah, sorry, it's I think it's your summary 210 is where I was looking at. I'll not explain it. No. Oh dear. It's all right. I will find the reference in a second. Yeah. Okay. It is. Sorry. It is your main proof, page 10, paragraph 210, the last part of it. You explain that you got the Visim model and traffic flow data from Mr. Budd at the end of August, with the Linsig and Arcady assessment received on the 23rd of August. And then you say this requested trip matrices were not provided, but in an email dated the 26th of September, the appellant confirmed that the trips across the network had been reduced such that only 30% of the food store trips were added to the network and that no trips had been reassigned from other routes. And you then used that as the basis for your discussion in section 7. Now, Mr. Budd responded to that in his rebuttal, page 4 of his rebuttal, and he explains that he provided an Excel spreadsheet with all the trip demands and routings for his 30% new, 70% pass-by assessment, and he indeed had checked that you'd actually got what he sent. And he goes on to address what you say in 210 at 2.4. He says that you state at the end of 210 that I'd confirmed that only 30% of the food store trips were added to the network and no trips had been reassigned. I'm afraid that my explanation has been misunderstood, and he says an examination of the Excel spreadsheet provided would have shown that the volume of outbound trips from Zone 1, the appeal site, was equal to 100% of the total outbound flow summarised within the TRICS assessment of the site within the submitted TA. In other words, it included in Zone 1, where the appeal site is, all the trips generated applying the trip generation rates from tricks. And then he says that the volume of inbound trips to Zone 1 was equal to 100% of inbound flow summarised within the TA. And so the total number of trips in and out of the zone, representing the appeal side, was equal to the level of demand modelled in LINSIG for the site access. In other words, he's included all the trips of all the people going to and from the store in that zone. Do you understand that?
Yes, and I agree that the turning movements in and out of the site do represent 100% of the flows to that store. It's just how those flows have been derived, whether they have been taken off as pass-by traffic, which is what I was trying to explain earlier, probably not well enough, that there's a reduction of trips on Ongar Road shown when you compare the matrices with the Stantec flows, that there's been a reduction of 50 trips northbound and 39 trips southbound, which have been taken off. So although they might be actually turning into the store, which is correct because it's all new traffic to the store, they have still not been applied to Ongar Road in a way that we would expect them to be applied.
Modelling, if that's okay. But just to stick with this point, so your understanding, and indeed the way in which you address Mr. Budd's 30% food store trips approach, you said that you had understood that the trips across the network had been reduced such that only 30% of the food store trips were added to the network. That was a misunderstanding, wasn't it, on your part?
There was a slight misunderstanding that, well, that's what the letter, the email from Jim, which might be HG1, does say, because I was trying to clarify, we didn't actually have the diagram network, so it's quite difficult to actually assess when you've only got the matrices where the traffic coming from going to, which should be taken on board, which is why I actually the diagram, so that makes it absolutely clear what needs to be taken off and added to something else. He does say, all I have done is add 30% of delivery traffic to the entire network in this scenario. So that was what I had taken that from his email, and also in his spreadsheet, which is in his rebuttal through 2.2 on page 4, the title of the spreadsheet is 70 pass by 30 new. So again, that indicates that he's applied quite a lot of pass by and not diverted. I don't know the title of it, but that's actually what it says.
Had you opened the spreadsheet before you wrote your proof?
Yes. And
Right.
And in terms of that, there has been some allowance, as I said previously, there has been some allowance for traffic not doing the movements, the head movements, so diverted traffic was installed. Has been. There's still a lot of traffic that is on Ongar Road that's actually just been taken off, which suggests that it's passed by rather than diverted. Because we would expect that it's diverted traffic, that traffic would be new to Ongar Road and therefore not resulting in such significant reductions in trips on Ongar Road.
All right, thank you. Now, let's turn then, please, to I want to deal with the issue of traffic generation and see where we get to, first of all. The Mr. Bard deals with that in his proof, I think at page 27. That's where I need to take you first of all. And at table 4.2, we've got the AM and PM peak hour trip rates.
Sorry,
Yeah, page 27, table 4.2. We've got existing trip rate generation, so this is what the industrial estate would generate if it were operating, the part of the reference case, yeah? All of that's agreed as I understand it. Then we move on to the proposed food store trip generation, and we've got table 4.3. Now, just to complicate matters, the adopted assessment flows relate to a slightly larger store that was proposed earlier in the process of 1,522 metres squared of sales floor area. But in fact, the appeal scheme is 1,413.8 square metres of sales floor area. That's right, isn't it? And so when we're looking at the modelling and the modelling output, we need to remember, don't we, that what is being assessed is a store which is a little more than 100 square metres smaller than the store that's actually being assessed in the model. Yes, but it does, however, impact upon the figures in the peak hour, and particularly in the Saturday peak hour. We can see the numbers we're talking about there, but it's a factor that we would have to think about if we're thinking about how robust the modelling has been. Yes?
Yes, I accept
Yeah.
it is a small store.
In relation to the residential trip generation, the assessment is then set out, and the previous quantum of development of 80 flats has been retained, notwithstanding that 46 flats are actually proposed. Yes?
That's correct, yes.
And we can see the reduction that would make if you applied the 46 as opposed to the 80. And we can indeed combine those with the figures from table 4.3, can't we?
That's right, but again, they're not huge numbers.
Yes, but they're starting to get up to reductions of around about 10%, aren't they?
I haven't actually done the maths, but looks like there's about, on Saturday departures, about 15 vehicles and 13 vehicles on arrivals, and 11, 12 vehicles during the weekday peak in the evening.
Mr. Budd then comes to the net traffic generation, and he sets out the figures for the proposed less the existing, doesn't he, at the bottom? So, in other words, what additional impact the scheme will have over the reference scenario in terms of traffic generation. Yeah? And we can see that the highest level of traffic generation is the two-way figure for the Saturday peak, 291. Weekday AM, we have an additional 32 two-way movements in the AM peak hour, and the weekday PM we have 158. Yeah? Thank you. So those figures are relatively small changes in terms of the numbers of vehicles on a road during a peak hour, aren't they, in a town the size of Brentwood?
In terms of the overall flow, they are, yes, there's a small proportion of it. But there's still new trips added to the network at that time.
To the traffic counts that have been undertaken, just to kind of see what sort of, how important they are, in fact. And Mr. Budd has undertaken some up-to-date traffic assessment in his produced traffic counts in his evidence, and he refers to those in his section 3. Let's just have a look at those. He turns to traffic surveys on page 16. And he explains that further full turning counts were undertaken at the junctions of the A128 Ongar Road North Road and A128 Ongar Road William Hunter Way on Thursday the 7th, Saturday the 9th, and he's also got further survey data that he produces in his table 3.1, in which he compares counts from 2014, 2018 and his own ATC data from 2022. Yes? And the 2022 data he's used, although he measured a period that included a period when the schools were shut, he's only compared, hasn't he, with data in the 7-day period from Wednesday the 8th of June to Tuesday the 14th of June when the schools in Brentwood were back. That's right, isn't it? And just so that we can see the picture here, we can see from this data that the AM peak two-way flow has reduced from 2014 to 2022, and indeed from 2014 reduced to 2018, but with 2022 being the lowest. PM peak, there's a slight increase from 2014 to 2018, but then a reduction to 2022, and Saturday there's the same data, amazingly, for 2014 and 2018, and then a reduction in 2022. Mr. Budd ventures to suggest that the consequences of the COVID-19 pandemic and a perhaps general shift towards more flexible working accounts for the reduction in the travel data to 2022, doesn't he? Do you think he's wrong in that?
I think the 2022 counts are not necessarily representative of actual flows. That's because the flows were undertaken in the height of the fuel crisis, and therefore, we can't be absolutely sure about the validity of them. And also, you shouldn't really be comparing automatic traffic counts with manual classified counts, because they're totally different. The way the data is collected is very different, so they're not actually comparable. So I think just taking those manual classified counts and the ATC data with the possible discrepancies that there might be doesn't give a true representation of a total, a comparison in flows. And in my evidence, I've included some data, some national data, which shows that traffic flows are getting back to pre-COVID levels. And that seems to be the general picture over Essex as a whole, is that traffic has got back to 2019 pre-COVID flows. And I accept that travel patterns have changed because obviously more people are working from home, but that seems to have changed people's travel behaviour, so that traditionally they would have done a commuter trip in the morning and the evening peak hour, but now people are more flexible, so they're taking the opportunities to do other trips during the day, and you know, so it's not necessarily working 8:30 till 5:30. You're more flexible in terms of your working hours. So trip patterns have changed, but we are definitely seeing on the network, I mean, you can see in Brentwood itself, that peak hours are still as congested and as busy as they were pre-COVID. So I think just by this comparison doesn't give a true representative picture of the traffic flows.
We can
I just don't think that these traffic flows, the surveys are comparable. So I think that's our position is that the
what recent traffic data than 2018 do you produce?
I'm sure there were traffic counts for the local plan modelling, but they're not counts that were undertaken by Essex County Council. They'd be undertaken by Stantec to put in the local plan modelling. But they, I think most of the modelling was based on 2017, and then they would have been growthed, and then there would have been some validation counts and some additional counts carried out in 2019. But I'm not sure at what locations they would have been carried out.
So that dip there's about 850, and then if we go further to the right, we get to the highest peak, just around about 1200, don't we? At some point, I think it's about 1900, maybe 2000 hours. That's a difference. 850 to 1200 is a variation of 350 vehicles in the data. Yeah? And we saw that the AM peak hour generation of 32 vehicles, that's well within the sort of fluctuation we're looking at here, isn't it? 32 vehicles in an hour. It's nothing compared to the sort of daily variation we're seeing hour to hour in the data. Do you accept that?
Yes, there is a fluctuation. However, you still have to look at what impact the traffic generation has as a whole on the network.
Yes.
So, and also, I mean, like the drops. I think that's probably about 7:30, 8 o'clock. That is the suppressed demand that we were talking about. The fact that the network actually can't process the throughput of traffic, so that's an artificial low of traffic because the network is so congested that the traffic physically can't get through. So flows would, if the capacity of the network was better, those flows would be higher.
But we know that the capacity of the network's better because we get to 1200 at 7 o'clock at night, don't we?
But that just shows that there's a greater throughput of traffic, probably because there's less congestion, and the congestion has gone by that time at night, and therefore there's more free flow conditions to allow that to actually happen. So, I mean, these counts are on the road, and obviously things like downstream of Wilson's Corner is not as bad, and therefore you get a better throughput of traffic.
The exercise I did with the AM peak, we looked at 32 movements. If we look at the PM peak, 158. That again is well within the sort of daily fluctuations that we're seeing, isn't it?
Yes, it is, but again, you have to look at the impact of the traffic generation on the network as a whole. Whether that's within a range of the fluctuation in traffic or not, you still have to consider the overall impact of the total traffic generation on the network and what that will do to it.
So you're saying you another hour?
That was another hour and a half to 2, I would say.
Okay. We should do it. All right. 9:30 tomorrow? Would that help? Is that all right with everybody else? Yeah? Oh, we'll bring you some food. You've got to stay here. So. No, seriously, Mr. Upton will tell you you're in theory impaired, so you've got to watch the footy on your own. Right, in which case, must admit, I was sort of expecting you to go on till about 5:15, so that is joyful as far as I'm concerned.
I mean, I could do that if you want me to, but it is quite number heavy.
Okay, I think perhaps, yeah, fresh tomorrow morning. Yeah, okay, in which case we'll adjourn until 9:30 tomorrow morning. Council, do I keep the keys to the room and the pass, or do you want them in and give them again tomorrow? Okay, thank you. Right. Okay, in which case, thank you all. I'll see you at 9:30 tomorrow morning.